May I please your lordship, my lord. May I please your lordship, my lord.
Yes, please.
My response submission, my lord, with due diligence, my lord. The order passed by the learned single judge dated at 29th of March 2022 is hereby challenged by Annexure 1. My case before this honorable court is, my lord, the learned single judge neither gave own finding, letter, remitted the matter back for consolidation or adjudication. Even if the property in question being settled by the consolidation authority, that is the Deputy Director Consolidation Authority under Section 12 of the Act in favor of the appellant, and that order was by Annexure 9 of the single bench order, and that order was also confirmed by the Learned Commissioner under Section 36 of the Act in favor of the present appellant, my lord. Even if the appellant being succeeded before the all consolidation forum, my lord, the Learned single judge again adjudicated the matter before the consolidation authority. This is wrong, my lord. That's why this writ application is preferred, and I may be permit let the matter be admitted for sake of the interest of justice, and interim order may kindly be passed, staying the further proceeding of the Learned single judge order, my lord, by the Annexure 1.
My lord, in the impugned judgment, the honorable single judge has remanded the matter to the consultation officer.
Correct.
Simply.
My lord, my lord, my lord.
Instruction is that.
And
the
this, so you have to appear before the consolidation officer on 11th April. So by now, what happened on? No, what happened on 11th April, sir?
My lord, consolidation authority in the earlier occasion already disposed of the matter in my favor, my lord. That is the appellant favor. In the duty order is concerned, honor section 12.
Mr. Panigrahi, right? Mr. Panigrahi,
my lord.
The impugned order asks you to appear before the consolidation officer on 11th April 2022.
My lord.
What happened on that date, sir?
My lord, that date only I have appeared, nothing has been done, my lord.
How can it be, sir?
No, my instruction is that the matter is sub judice, and he has given me in writing that the consultation officer is in the session of the matter. He will pass the necessary judgment.
I see.
In pursuance of the direction of the honorable court.
All right.
By the honorable single bench. So
all right.
All points which he wants to raise in this appeal,
yes,
he may
raise
it before the consultation officer.
All right.
He will take.
All right. You say the present appeal is directed against an order dated 29th March 2022, passed with the learned single judge in OJC number 3758 of 2000, remanding the matter to the consolidation officer for a fresh adjudication. The impugned order required the parties to appear before the consolidation officer on 11th April 2022. The court is informed that on remand, the consolidation already seized of the matter. Full stop. In that view of the case, the court is not inclined to interfere with the impugned order, except to clarify that it will be open to the present appellant to raise all the points urged in the present appeal before the consolidation officer in accordance with law. Considering that it's a considerably old matter, the consolidation officer is requested to dispose of the proceedings as expeditiously as possible, and in any event, not later than 31st December 2022. The appeal is disposed of in the above terms.
Supplementary list item number 2.
My lord, I am on behalf of appellant. My lord,
BC Merit.
Yes.
Respondent number 1.
All right.
my lord, delay only 24 days, my lord.
All right. The delay is condoned. What's the matter about?
Matter about rehabilitation appointment in case of a cooperative society, my lord.
Right.
The appellant is a cooperative society having special law, that is a policy.
Right.
My lord.
What
The honorable
order do?
Annexure 15, honorable single judge passed order at the stage of admission, my lord. No opportunity have been given to the appellant, my lord, appellant of bank. And quas the order under annexure 13, my lord, that is a speaking order. Annexure 13, page 61, my lord. This order, the opposite respondent number 1 had applied rehabilitation assistant in a new room. That was not considered because she has not fulfilled the criteria. This is a cooperative society, my lord, having special law, HR policy. Rule 80 provides the person shall apply within 1 year. This is the father of the respondent had died in 2012. She applied rehabilitation assistant in 2019, my lord.
That's all right, sir, but the rules that will apply are not the 2020 rules.
Yeah, my lord, our rule is a special rule. All government guideline is not applicable to the cooperative societies.
Who's appearing for the other side?
My lord, I'm the respondent number 1, my lord.
Yes.
My lord, sir, please to allow the appeal on 15/11/2021 as per order number 3, wherein the order passed by the honorable single judge in 23693 of 2021 was allowed, recalled, was set aside. Thereafter, I filed a review application number 240 of 2021, where my lords have been pleased to allow the review as per order number 1 dated 8/4/2022.
No, you're taking time to file a reply. Do you want to file a reply?
Yes, my lord, 2 weeks. My lord.
My lord, interim order may pass to stay operation of the.
My lord,
Is
sir,
there a
very
contempt
pleased to-
petition?
I have filed a stay.
No, is there a contempt petition, sir?
No.
Then there's no question. Sir, do you wish to file a reply?
My lords. My lord, sir.
You had already taken time, sir.
My lord, sir, due to my illness, continuous illness, I could not.
All right, counsel for the respondent number 1 seeks and is granted the last opportunity to file a reply within 4 weeks. Rejoinder before the next date. 22nd November.
My lord, appeal may be admitted, my lord. Admitted.
There's no need for that, so we can hear it on that. The delay is condoned. Right.
Item number 3. Item 3.
My lord, there is a noting order number 3 dated 8/8/22 may kindly be seen IN number 1026 of 22.
Anyway, admit LCR has already been requisitioned.
My lord.
The paper books be prepared and supplied to parties within 8 weeks. The fine amount be stayed. That IA is disposed of. There is no bail application yet.
Item number 4.
To be included in the list of final hearing matters.
Fiction under section 302, my lord. This is appeal was
Just say admit the LCR be requisitioned. It's already there. The
already
LCR is already available. You say the paper books be prepared and supplied to parties within 8 weeks. Fine amount be stayed. Realization of fine be stayed. Bail application is not pressed at this stage. All right.
supplementary list item number 5.
My lord, item 5, my lord,
Yes.
directed.
Yes.
Just, my lord, for proper assistance, my director is with me, my lord. If you
Yes.
want, then we can also physically present with the court. But the thing is this, we have filed the counter on behalf of AIMS, my lord.
Right.
And All India Minister of Medical Science is ready and willing to give all sort of assistance.
Huh.
But the cost factor is concerned, that is very expensive. And this present director is also earlier in the AIMS, and he has treated many patients in this regard. According to him, in this particular disease, there is a multiple of other factors are there that should be required to be treated. Suppose a patient is coming and he has that disease, then sometimes his problem of cardiac, sometimes he may have a problem of rheumatism. All sort of treatment as we are already been given, my lord. It's not that we are not giving the treatments. So, but this cost, but as far as the cost part is concerned, there should
So
be.
the same argument was advanced before the Delhi High Court.
Yes,
It was
sir.
negative. The SLP filed against that has already been dismissed. The
that
same
part,
argument was advanced in the Delhi High Court, sir.
And my lord, no separate counter has been filed by opposite party number 1. How they can adopt
Well,
the
it is under
how
the
they can
process.
how
we
they
file
can
very
how they
shortly.
can adopt the counter of AIMS, my lord, because the fund is being that will be allocated by given by the Union of India, not by AIMS, my lord. AIMS executed, my lord. Union of India has not by yesterday.
Definitely, we are not disputing on these things. We are not disputing.
Yesterday, my learned friend said that he has filed the counter through my lord mail, and he will serve the copy to me. And today, my lord, the copy has been served to us again, my lord, by opposite party number 5, And my learned friend says that they are adopting the counter of AIMS. How can it be, my lord? They should come forward to say that this is the amount which we have allocated for this type of diseases, and that has been taken
instruction
note
I
of.
didn't have, man.
That has been
instruction I didn't have.
that has been taken
Because-
note of
because
by
the- because
that has
beyond
been
the scheme,
taken
we
note
cannot go ahead.
that has been taken note of by Delhi High Court, my lord, in I've drawn my lord's attention to
No,
paragraph
so how many people are there now? 16,
15, my lord.
15.
15, 1-5, my lord.
All right. Where are they? They're all over Odisha.
They are all over Orissa, my lord. I have given their address also.
Where
My
is
lord,
that?
I have seen one child, my lord.
May I pray one thing, my lord? May I pray one thing? What we have discussed now, may I pray that the government of India is going to file their counter. We have under the process. So as
So
regard
that-
to,
all that can happen.
I am agree with the, my lord's decision that they have Delhi High Court as well as Supreme Court, all these things, as well as my lord senior is submitting all these things, funds allocation. In that respect, definitely the government will take a decision because
And
it is not
yesterday-
covering the
yesterday-
scheme. What scheme
And
we have annexed in our annexure, that is the common scheme for rare diseases.
So
So-
it's very simple, Mr. Paddy, it's very simple. In the Delhi High Court, the same argument is advanced, and the Delhi High Court rejected the argument saying financial difficulty is not going to come in the way of providing treatment for these rare diseases. And that was taken to the Supreme Court. The Supreme Court is declined to intervene. So all we're going to say is, if you can comply with the Delhi High Court order, you might as well comply with a similar order passed by this court.
My humble submission to my lord, that
No,
what,
when you want to comply, we'll ask you to first examine all of them. You start the treatment, we'll see this for the Union of India to reimburse the cost of treatment. What is cost treatment? cost to India is-
according to the director, my lord, according to the director,
Which
he is
funds the
saying
funds for it.
they are extending their treatment facilities. They are
Yes.
giving the treatment facility till date because the patients are particular in category. They are coming where they are providing the treatment because they are
No,
coming in
so-
different way.
No, Mr. Pai, so we'll record your submission that these 15 people are already getting treatment or
It's a wrong statement.
Anyway, let him-
No, my lord, according to my lord's, the director is very much present. If you lordship want,
Rather the state government.
No, you make a statement, we put it on the record. If you say we're already receiving treatment, we'll record it.
My lord, according to the financial part is concerned, lordship may see the paragraph 6 of our counter, where specifically said that as regard to the finance part is concerned, as regard to the given treatment, we don't have any stand. We can't not stand on the way. But as regard to
The
the
Union of
financial
India
part
has to
is
reimburse
concerned,
the
we have
cost.
some restriction, my lord.
So the Union of India will reimburse the
Well,
cost.
Union of India has not filed the counter ballot. How can they say counter filed by us? The counter has been filed by opposite party number 5. Today, the copy which has
My
been
lord,
sought-
my lord, my blonde senior friend might have. Us means the government of India as well as AIMS. It is not that
How?
I am segregating
They are
myself.
separate parties. At least the counters would have shown that it's by opposite party number 1 and 5. But it said today, ballot that yesterday copy was sought by opposite party number 5. The same counter has been given to today with opposite party number 5. It has not been changed. If my Lord friend has directed
Number
them
5 is filed the
that
counter.
they are
Union
adopting
will
the
not
same
file till date.
counter, what made them not to change it to opposite party number 1 and 5?
All right, all right.
How they're taking it lightly in the light of
A counter affidavit has been filed. You said this is a petition seeking directions to the Government of India as well as the state of Orissa to provide treatment, to provide the antisense oligonucleotide bracket AON therapy free of cost to 15 children at various locations in Odisha suffering from Duchenne muscular dystrophy bracket DMD. This petition was first listed on 21st June 2022 when time was sought by the learned additional government advocate for the state of Orissa for instructions. Stop. On the next hearing, 11th July 2022, the court was informed that the High Court of Delhi had in writ petition civil 9684 of 2021 bracket Adhyan Jaiswal versus Union of India passed orders on 14th December 2021 and 1st February 2022 issuing directions to the Union of India bracket UOI to provide such free treatment to children suffering from DMD. Full stop. Similar orders had also been passed by the Calcutta High Court in CPAN number 564 of 2021, in WPA 4016 of 2020. Paragraph. The court has been informed that the aforementioned order of the Delhi High Court was challenged by the Union of India by way of SLP civil numbers 10152-10174 of 2022 in the Supreme Court of India. Full stop. On 11 July 2022, while disposing of the SLPs, the Supreme Court of India declined to entertain the SLPs while granting liberty to the UOI to advance its submissions before the single judge before whom of the Delhi High Court, before whom the matters were still pending. Paragraph. Counsel, Mr. Dalal, senior counsel to the petitioners, urges that directions similar to the ones issued by the Delhi High Court in its order dated 1st February 2022 should be issued in the present case as well to the Union of India. Paragraph. Mr. P.K. Padhi, Learned Assistant Solicitor General, Government of India, representing both the through the Department of Health and Family Welfare and AIIMS Bhubaneswar, bracket opposite party number 5, refers to the counter affidavit of AIIMS Bhubaneswar to urge that the AON treatment is expensive involves very high cost and lifelong therapy, and therefore the National Policy for Rare Diseases 2021 will have to be applied, finding the resources to provide such treatment is concerned. Full stop. A reference is made to a digital portal for crowdfunding and voluntary donations for patients of rare diseases, which has been made functional. Paragraph. Mr. Padhi adds that while AIIMS Bhubaneswar will not hesitate to provide treatment, the cost of treatment will have to be reimbursed. Paragraph. As far as the above submission is concerned, the court notes that a similar submission was made before the Delhi High Court and negatived by it in its order dated 1st February 2022, where in para 9 it was observed as under, take para 9 of that order. Paragraph. It is the above order that was challenged before the Supreme Court of India and was not interfered with. Full stop. Consequently, a direction is issued to AIIMS Bhubaneswar to provide treatment to the 15 children.
Other children are there, but these 15 parents, they had approached me for that.
So let us make a beginning, sir.
That's the beginning.
And the cost of treatment would be reimbursed by the Department of Health and Family Welfare, Government of India. Full stop. when will you drop a time schedule? So let's the medical superintendent aims drop a time schedule when these children can come and consult to begin with, sir. Mr. Padi?
Yes, my lord, can you 15 days, my director is saying 15 days time may be given. We'll make a particular.
No, within a
arrangement for-
week, so not 15 days, just to drop a schedule, who should come and meet and which date? Because some of them may be outside,
16, 23rd.
within a week.
26th, my lord, 26th. Today is 16th, 26th.
No, but, sir, you start from Monday onwards, you start seeing 2 children on Monday, 2 on Tuesday, like that. Give
That
us
you
a
can
schedule.
do. That we can do. That we can do.
You say in consultation with, Mr. Padi will in consultation with counsel for the petitioners and instructions from the medical superintendent AIMS Bhubaneswar, draw up a schedule.
Director superintendent, director AIMS.
Director AIMS
Director.
Bhubaneswar, all right. Draw up a schedule for consultation of these children with the in AIMS Bhubaneswar to commence the treatment. Full stop. An affidavit of compliance be placed before the court on the next date. October, sir. Let's keep it for 11th.
Yes,
All right.
definitely will
The
extend.
order
our
be
efforts, my lord.
uploaded today itself. All right.
Will. I love you.
Supplementary list item number 6.
May I please? Lakshmi, see the 3 matters are there. I am for in read appeal number 321 of 2022. And my land stand is appearing in CRLMC 562 of 2021, the last matter.
So how is the CRLMC coming with the writ appeal? I'm not able to understand.
I don't. The same.
In fact, Lordship, while taking up criminal miscases, Honorable Singh, relying upon the statement announced to the Vigilance Council that the writ appeal is pending, that has been tagged, this writ appeal has been tagged to that criminal miscases, Lordship.
How is that possible?
So it can be deleted, madam. It can be deleted and advocated in appropriate.
No, what is the connection? I'm not able to understand. What's the connection between this criminal?
What has happened in this rate appeal? Direction has been given by honorable single judge to promote him to the post, to higher post during pendence of a criminal case. Departmental proceeding and criminal cases both are pending. And but the departmental, he was ignorant in the departmental. Why is it? I don't know.
You will get your turn, Mr. Dalai.
He was ignorant in the departmental proceeding, but still criminal case is pending. So,
So he's filed a 482 for quashing of the criminal case. But that doesn't mean it gets tagged with this.
yes, madam.
And a Lordship judgment is there, Lordship.
Works on the submission of the Vigilance Council that has been tagged.
My lords, CRLMC.
Lordship, relying on Ashish Suryan's case, Lordship, given a judgment, Lordship, when criminal cases, when he's been ignorant from department proceeding, so no need of Lordship proceed with the criminal case, Lordship.
No, in the CRLMC, this judgment will be postponed.
Lordship, that's
Sir.
because it is tagged here, we are not unable to remove that matter, Lordship. That's why Lordship delete that matter, Lordship.
So this is not correct. Your lordship, what should happen in CRLMC? Let that happen.
Lordship.
My lord, your lordship kindly has to glance to.
See, it has to go to a single judge, CRLMC. We can't simply tag it to the written.
He was that there is a direction by the division bench to frame the charge and conclude the trial. So your lordship kindly have glanced to the writ appeal order dated 5/7/2022. There was the petitioner's prayer, the defendant's prayer, the opposite party's prayer is to conclude the trial within to fix a time. For that purpose, for the purpose of
No. How can it be, sir?
3. Order number 3. Order dated 5/7/22. Serial 3. So there is a prayer to fix a time for conclude the trial.
No, this is all, see, this is presuming that there's no 482 at all.
That is not like that.
There is a 482.
Sir, dealing from this writ appeal.
So
After that, the hearing is going on in criminal proceeding also.
sir, the 482 anyway has to be dealt with by the.
It can be delayed, my lord. How can be delayed?
You say the criminal MC 514 and 562 of 2021 be delinked from this writ appeal and be listed before the roster bench of the learned single judge on 26 September.
of legislation.
All right. So and the main writ appeal, what is that? We just await the.
Lordship, will outcome of the criminal miscase, Lordship.
Similar matters have been fixed to 28th October.
We can fix this.
Yes.
All right. List on 28th October 2022, interim order to continue.
Much.
All right.
All right.
Supplementary list item note 7.
May it please your lordships. My lord, I have prepared a short note, my lord. The prosecution case in short is that, my lord. That the informer, my lord, deceased, my lord, is a small boy, my lord. He was missing from 5 to 6 days from his home, my lord. The story is that, my lord, the prosecution is, my lord, 3 juveniles, they had been sent to Juvenile Justice Board, my lord. This present appellant and another appellant, my lord, both were called to the and these alleged that this present appellant and another appellant, my lord, who was acquitted, my lord, they were taking his son with them on 28/10/2012 evening, but the next day, my lord, they all came back, my lord, except this informant's son, my lord.
Right.
He called a village meeting, and my lord, there these all children told that they do not know what about him, my lord. Thereafter, my lord.
So except this appellant, the other 3 accused were juveniles.
Yes, my lord. They were
and in that JGB, they've been acquitted.
No, lord, they were the Juvenile Justice Board, my lord.
What happened in the JGB?
I cannot say, my lord.
You should know, Ms. Patnaik.
With this present appellant, my lord, another appellant was also there. Here, my lord, two persons to trial, not the juveniles, my lord. One was acquitted in this by this learned court, my lord. But the
juveniles were forwarded to the JGB.
Yes, my lord. That information.
It says convicted.
My lord, what happened to the juveniles, my lord?
No, but that's how you've written in this note. Just come to your note.
My lord, only regarding this appellant only, my lord, I am appearing. Another appellant was also there, my lord, who was also not a juvenile, but he was acquitted, my lord.
No, just see what you've written, madam.
Yes, my lord.
The IO sent the dead body for PM examination.
Yes, my lord.
Exhibits to SFSL. Submitted charge sheet against Ranjan Nayak, Sudhir Mohanty, Kalia and Tutan Biswal. Being juveniles forwarded into JJ Board Sambalpur, convicted.
Yes, my lord.
So the juveniles are convicted.
Yes, my lord. Juveniles are also convicted and sent.
Just now you said you don't know what happened to the juveniles. So now you ask you to read your
whatever in the record, that only I am telling, my lord. I do not know.
When we asked you, you just now said I don't know what happened to the juveniles.
I do not know what happened to the juveniles.
What did you written here when they were convicted and 303?
I have specifically told that these juveniles sent to.
You're not even reading what you've written. Just something you've dictated.
Yes, my lord.
You've not checked. You've simply handed it over to your
my lord. I have checked and I have handed over to your lordship. My lord, I am reading that portion, my lord. On 28/10/2012, some deceased over phone intimated the accused Ranjan Nayak, Sunil Mohanty. I am for the appellant Sunil Mohanty, my lord. Ranjan Nayak also, my lord, acquitted from 2002 So,
Anyway, madam,
my lord.
you have not, I don't think you've understood. You want to say everything that you said is correct, right? You don't want to admit you made a mistake in this.
No. No, my lord.
Whatever you said here, according to you is correct or not?
Yes, my lord. It accordingly correct, and also I am pleading only for
It's
present.
all right. It's all right.
Yes.
All
Therefore, I cannot say what happened to those children.
You said here, madam, although you don't know what has happened to others, here has been committed.
See the record, my lord, that only I have written, my lord.
Does the record show that the juveniles were convicted?
No, my lord, they were sent to juvenile justice board, my lord.
What you written there? You are reading what you have written.
That may be the typographical mistake, my lord, not
No, after 5 minutes, you now finally admit you made a mistake.
the typographical mistake.
It takes you 5 minutes to admit this, madam. You're so casual about it. It's somebody's life, correct? And this is a high court you're arguing before. And this is a seriousness with which you deal with the matters.
My lord, shall I continue?
Mechanically just dictated something. Yes, Ms. Patnaik, you tell us
Yes, my lord. My lord, I'm sorry, I don't have the information about the juveniles, my lord.
anyway. Tell
But
us what about this man.
Nevertheless, here, my lord, I must fairly submit, my lord, most of the hostile. So it is only the family members, the father, brother, and 2 sisters. The prosecution has tried to prove that they had last seen with them. They had.
Is that the only evidence? The only evidence last seen
Only
is that-
evidence, and there is a call details. The sister says that on 28th evening, when my brother went away with these people, I had called on his mobile, and he said that I am with these people. We will be going to Sambalpur. That call record has been verified. That is at, if you like, take your lordship to.
No. To link this particular appellant to the crime is the only evidence is the one of last scene, or is there any?
There is a leading to discovery, but the witness has turned hostile, my lord.
No, which is why you see the point is this.
The point is
With 4 people. And you don't know what happened to the other 3. All of them also sent.
other one is with this person. He has been acquitted. One, my lord, he also stood trial in this. He is Ranjan Kumar Naik.
So what's the distinction? What is the distinction between his case and this appellant's case?
My lord, the main allegation against Sunil Mahanti had come and taken. He was the one who came to the house, and this boy has gone with him. And over phone, he has informed that I have come with these people. He has named them, and we are going to Sambalpur. And it is Sunil Mahanti discovery of the dead body. But that witness has turned hostile. So these are the 2 things. That another thing is that only one other thing is that the CDR was verified. And on the 20th evening, when the sister said,
how does the chain get complete? There are too many gaps.
The prosecution must have found it very difficult because all the independent witnesses have turned hostile, my lord. Person, the Caesar, the people who said last seen with them.
All right, orders reserved. Orders reserved. Oh, all right.
List admission item number 1.
Milords, the arbitration clause. The arbitration clause is at page 63. It was a 3-tier arbitration. First tier was amicable settlement. Second tier was the nominated, the DRP, the nominated adjudicator. Third tier was arbitration. Now, Milords, at page 436, Milords will find my claim letter. There is no amicable settlement. At 445, Milords, I send a letter to the adjudicator. At 449,
Why are they separate petitions? They're separate claims, is it?
separate agreements, Milords.
Agreements. What's your difference?
As I, as my issue notice, I'll take instructions.
No, this is not after notice.
No, Milords. No,
Notice. All right, Mr. Mohanty accepts notice in 6 time for instruction. 14th October.
Milords, just one. Other than this 8, another matter. ARBP number 59 of 2022, exactly same matter. It will be taken up on record and
Yeah, taken on board that 59 and notice in that also.
much of
There's a copy of that maybe.
I've solved. Actually, it is solved as of now.
All right.
Supplementary list
Much
item
less,
number 2.
May I please, Lordship?
Yes, please.
The arbitration clause is at page 35 of the brief, clause 15.
All right. Notice returnable.
Yes.
We are appearing, my lord.
You're there.
Yes, for OP number 1 and 2. Yes.
So are you agreeable, sir, to appoint an arbitrator?
Is there?
We'll file the counter, my lord. Thereafter, lordship may decide.
All right. Mr. Party accepts notice for opposite parties 1 and 2 and states that he'll file his counter affidavit within 4 weeks. Rejoinder if any before the next 21st October, sir.
Item number 3.
In item number 3, my lord, I beg to appear online.
Yes.
Myself, Kishore Datta, my lord, from Calcutta.
Yes, sir.
This
Yes.
is section 29A application, my lord. We are seeking
For extension of time.
Yes, my lord. Now,
Mr. Party, you're there in this.
Yes, they filed lordship case with lordship. We have filed application earlier.
I know.
There's the same out of the same lordship. Some other day in the meanwhile, I have to enlighten you.
It's just for extension of time, sir.
It is extension time because many issues there is required to be enlightened with my lord. So I don't have an objection. Lordship may keep it some
we
other
don't
day.
go into the merits. The only thing is, if the arbitration is ongoing, then it might as well agree to extension of time to complete it.
It was going on because my lord has dismissed our application which was filed by us. Thereafter, they have filed a retractation again that is withdrawn. We have filed an application, it was hard, and our lordship disposed it of with a direction. So this mandate will be continued, and the issue framed by us should be educated by the arbitrator. This issue is there. That's why I am praying, my lord. Let's may give that is 2 weeks time or next week. Let's may keep it. You can.
All right, Mr. Party, and 6 time for instructions. 30th September, sir. 30 September.
30th September. I'm grateful.
Supplementary list for admission item number 4.
My lord, the notice is given, but it is not served because the
addressee left without any instruction.
My lord,
So what do you do?
I'll find out the address.
The notice sent to the sole opposite party has been returned with the endorsement, open quotation, addressee left without any instruction. And counsel for the petitioner seeks time to ascertain the fresh address of the opposite party and file it in the registry within 4 weeks. Thereafter, fresh notice on the new address. Returnable on 28th. No, not even that. Sorry. Yeah, returnable 28th October. 4 weeks, 1 minute. 4 weeks will be. Sorry. Returnable 18th November. 18th November.
Obliged.
Right.
Item number 5.
My lord, item number 5, I am for the petitioner. Notice was issued on the last.
2 weeks time to file counter, madam.
You want to oppose this request? You want to oppose the appointment of an arbitrator?
No, my
Then? He's only asking for appointment of an arbitrator.
my lord.
Are you opposing it?
No,
Then you might as well agree on the name of an arbitrator. Why file counter? What is your claim, sir?
my lord. That's it, 12 lakhs 79,000 and
So we
975.
can have an advocate act as an arbitrator. Counsel for the opposite party states that he has no objection to the appointment of an arbitrator. With the consent of counsel for the parties, the court appoints
May I suggest for Saswat Acharya, Lord?
Mr. Sashwat Acharya, advocate practicing this court as sole arbitrator to adjudicate the disputes between the parties, including their claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. The High Court. All right.
Hello. Deeply obliged.
Item number 6, Lord, 6, 7, and 8. I just received the rejoinder day before yesterday. If your lordships can take it up next week, subject to my learned friend's consent. Because we have filed the counter regarding the maintainability, as I pointed out last time, your lordships, that the arbitration tribunal, the matter is pending there. And they have not filed anything for the termination of the mandate. They have come up directly in 11-6. So on that account, I have filed the counter. They have filed the rejoinder. So if it can be taken up next week, my learned friend is here, my lord.
All right. I've got the petition. Okay. Rejoinder has been filed by the petitioner at the request of Mr. Nanda Learned, senior counsel appearing for the opposite party. 30th September. All right. 6, 7, and 8. All three. All right.
Item 9.
We're giving a list of dates, my lords. It's for appointment of an arbitrator. But that judgment of the Supreme Court.
Lordship, I have also given a list of that.
There's a judgment of the Supreme Court now.
Yes, saying that when you have an arguable case, you appoint. When you have an arguable case, then you appoint somebody. It is to be decided under section 16.
No, my lords. My lords, here is a case, my lord, there is no agreement at all.
No, then
No agreement.
let me answer the petition.
It says tender has been cancelled. Your lordship judgment is that, my lords, 30 for an arbitrator. If my lords, tender is cancelled, there is no way successful bidder, my lords. And
No, that was in the sound context. I let me place my case.
Let him.
Yes.
Yes, sir.
Let me kindly see that date. We have a list of dates we have given. 23/3/2018, the tender was published. Then 26/6/2018, petitioner submitted its bid in response of tender notice. 7/2/2019, MCL issued a letter of intimation. This is important. Intimating that JMIPL was the lowest bidder. Then 8/2/2019, JMIPL letter of acceptance to the LOI. This is there at page so and so. 1/10/2019, MCL requested JMIPL to extend bid validity up to 22/5/2020 without any modification. Then 21/10/2019 extended the bid validity up to 22/5/2020. Then between May and August, there were several such requests we extended. Then on 14/6/2021, MCL unilaterally cancelled the tender and the LOI issued in favor of JMIPL. Then on the next page, JMIPL disputed a letter of cancellation and sought resolution of the dispute under 4A37 of the bid. MCL stated that cancellation of LOI is not a dispute in terms of clause A of the bid documents. This was refuted, and then my lords may straight away come to the clauses. So whether the contract clauses cover this is the question, my lord.
So page 144 is a clause.
My lord, so before that, may I just take into the definitions, because this LOI and LOA, they are defined. My lord, may first see page 41, clause 33.
Yes.
The detailed e-tender notice shall be deemed to be a part of the contract agreement. The general terms and conditions, additional terms and conditions, special terms and conditions, if any, technical specifications, drawings, and any other document uploaded on portal as per bid documents and work item documents forms an integral part of this bid and shall also form a part of the contract agreement. This, my lord, may kindly take note. These documents uploaded, all this is included. Now thereafter, my lords may see page 64. The relevant portion is towards the bottom, BOM operator or BOMA or wherever occurs means the selected bidder and shall include legal representatives of such individual or persons composing a firm or a company.
So there is no selection yet.
No, they have given us the letter of intent. We were the L1.
No, that's it. But just telling you that you're L1 doesn't mean you're selected.
Now, the judgment which they are relying upon, here the clauses, and let me come to the clauses, because there are two clauses which actually would indicate that interpretation of any of these documents would also fall within the purview of the arbitration clause. I'll come to that. My lord may just see these definitions because this will have some bearing on it. Page 65, my lord may kindly see. Page 65, contract. Contract shall mean the formal agreement executed between the owner and the selected bidder for setting up the washery, operation and maintenance thereof with terms and conditions mentioned therein, including bid notice. The bid, this my lord may kindly see, including bid notice, the bid as accepted by the owner. Now this has happened. Specifications, designs, drawings, and those to be submitted during.
Has the bid been accepted? See, the whole question is, has it been accepted?
Yes. Bid has been accepted.
No, where is that letter saying that it's been accepted?
My lord may kindly see the definition of LOI on the at page 67. First is letter of acceptance / letter of award. Then my lord may see letter of, below that, letter of intimation has been issued. LOI of the bid shall mean the official comment issued by the owner notifying the L1 bidder about acceptance of its bid.
So where is this, sir? Show me this. You're just showing me a definition.
My lords.
Show me this letter of intimation.
My lords. That's not disputed. They admit that this has been given. This letter of intimation is there. They are saying that LOI has not been issued. My lords may kindly see annexure 3, page 644.
Annexure 3, 644.
My lords.
644. So this is your letter. I'm saying thank you for
641. LOI is the 641.
641. I'm so sorry. So this is not disputed. That LOI has been issued is not disputed by them. They are saying that LOI has not been given and hence it's not a completed contract. I have judgments on record. I'll show them, which show that if formation of contract is an issue, you leave it under 16 for the arbitrator to decide. It's not something which to be thrown out at the 11th stage. I'll quickly show the clauses. My lord may see the clauses itself would make out a case for my client. My lord may, I was at page 65. Then my lords may see page 67. So this bid as accepted by the owner is included in contract. Then my lord may kindly see clause page 67. Letter of acceptance award of the bid shall mean the official communication issued by the owner notifying the preferred bidder about acceptance of his bid and inviting sign contract. Now, even in this, we have documents in the rejoinder which show that the board has actually said that the letter of acceptance is there and it should be awarded. So even in this, we have a case. But still then, even at this arguable stage, if we say that and we are at this LOI stage, still then in terms of a lot of Supreme Court judgments, we are covered for this matter to be decided at the section 16 stage. I'll just quickly show those documents. Lowest bidder is also defined. Then my lord may see preferred bidder. That's also a relevant definition on that page. then my lords may see page 68, selected bidder shall mean the preferred bidder that finally enters into a contract with the owner MCL for execution of the subject work of coal washery or BOM concept. Now, after this, my lords may kindly see the two important clauses are at page 140.
Is there a definition of successful bidder?
There is no definition of successful bid.
Oh.
Now, that's the reason if my lord would see the two clauses.
Clause uses the expression successful bidder, which is not defined.
What's not defined?
Why it's an arguable case?
Yes, and I would say now that we have a clean case, but for this court, at least what we have to show is an arguable case.
So the Supreme Court doesn't apply here?
No, in fact, we have judgments of the Supreme Court in our favor.
I'm saying specific to Mahanadi coalfields. There's a recent judgment of the Supreme Court.
That's different.
That's different.
That's different. Here, now, my lord may see the crucial clauses are at page 144. Let me show them.
That's right. That's what uses the expression successful bidder.
There is one more important aspect, my lords. My lord may see page 144.
Yes.
This fine line, they are not able to take it from us. My lord may just see page 144. Clause 4A.37, settlement of disputes.
Yes.
It is incumbent upon the BOM operator. Now, my lord knows that we are not a BOM operator. Petitioner is not a BOM operator in terms of the earlier definition. It is incumbent upon the BOM operator to avoid litigation and disputes during the course of execution. However, if such disputes take place between the BOM operator and the owner, efforts shall be made first to settle the disputes at the company level. The BOM operator should make a request in writing.
It is all about the BOM operator.
Yes. So what we are trying to show, my lords, is that there are two clauses. First one is settlement of disputes, where the expression used is BOM operator. Now, if my lord would see the arbitration clause, which is at the next page,
that uses the word successful bidder.
Since there is what
put into you, according to you, since it is not defined, it's an arguable case that you are a successful bidder.
My lords. And why we are trying to show the earlier clause is that even the realizes that there can be disputes before somebody is declared a BOM operator. That's the reason why I showed that.
All right.
So a conjunct reading of both these clauses would show, and my lords may just see that, may I just show that clause? Page 145, third paragraph.
Yes.
In the event of any question, dispute or difference arising under these terms and conditions or any condition contained in the contract or interpretation of the terms of or in connection with this contract, the same shall be referred. So this itself gives us a leeway to at least put this before the arbitrator, because what falls for consideration here is interpretation of the terms of all these correspondences and this contract. And in the rejoinder, we have minutes of the board which have said that you give him the letter of award.
Yes. What do you say?
The Lordship see. First, your Lordship see.
So Supreme Court orders are there.
All right.
Page 111, my lord.
Yes. Yes. Catch on.
General terms and condition.
Yes.
What is the contract? Defined in the.
Yes.
Contract is the duly signed contract from on judicial stamp consisting of following constitute the contract document. Here there is no.
You can't stop there, sir. The definition you have to define. If you look at
Lordship, one detail of tender notice, letter of intent, and letter of.
So it includes all of that.
Yes. All of that, my lord.
But so it does not. It doesn't mean that if there is not
included in the signed contract, my lord. Your Lordship, see Annex 2, page 641.
Yes.
Letter of intent.
Yes.
That is, your Lordship, see 642.
Yes.
Last line, my lords, you are requested to get touch in the GM washery himself for providing all the necessary assistance, support in obtaining environmental clearance or the statutory clearance, MCL clause 1.3.2.5, section 1 of integrated e-tender documents, REC and RFS, the subject work. The letter of award will be issued after receipt of the environment clearance in accordance with the terms and conditions of the bid documents, my lords. It's a Miller's conditional LOI.
So that is not the issue here. The issue here is here in terms of 4A, 37A.
Yes,
arbitration. Are they a successful bidder or not? That's the question.
Not a successful bidder.
Naturally, you have to say that.
Lordship,
You have to say that.
But your Lordship, that again, I'll.
What is the point of issuing an L1 if they're not the successful bidder?
Lordship, it is L1 bidder, my lord. Successful bidder.
Okay, there is somebody called successful bidder, you tell me that. Okay, no, one minute, sir. If they are not the successful bidder, who is the successful bidder?
My lord, success in the tender.
Sir, if they are not the successful bidder, who according to you is the successful bidder?
Lordship, see first 4A37. Lordship, see. Again, I'll place that.
Please. Why don't you answer the question first? If according to you, petitioner is not the successful bidder, that is what you have to argue. Because the clause which you are going to read, in the sense is a successful bidder.
When the contract will be executed between the.
You answer this question, sir.
When contract will be executed.
You not permit it's okay.
Successful bidder,
Just to ask me a question.
Miller, successful bidder, if both the parties enter into agreement, then he succeed in the contract, Miller. Not Miller, at the stage of L1 bidder, he cannot be treated as a successful bidder, Miller. That is a definite. Lordship, again, your Lordship, see the clause, Miller's 144. Page 144, clause 4A37, Miller. Settlement of dispute, Lordship. It is incumbent upon the DOC operator, DOMA operator to avoid litigation and dispute during the course of execution. That is the clause, Miller. During course of execution. Then you turn to Miller's 437, 4A37A, Miller's. Miller's in successful bidder and company fails to resolve the dispute difference by the in-house mechanism, then depending on the position of the case, either the successful bidder or the company shall give notice to other party, refer the matter arbitrator. Instead of direct approaching the court, the successful bidder shall, however, be entitled to invoke arbitration clause only after exhausting the remedy available under the clause 4A37, Miller. Settlement dispute. Settlement dispute category will say that during course of execution, Miller, of work, Miller. So general terms and conditions is not applicable once not enter into the agreement, Miller. That is a settled law, Miller. And the Lordship also, Miller, decided that once cancelled, Miller, any reason, this is not treated as a successful bidder, Miller. The Lordship decide that case. I have given that the order, Miller, your Lordship. And also your Lordship judgment. Lordship decided in Miller's ARB 69 of 21 Miller's, that is MQ Managing Director of Odisha State Medical Corporation and others. Miller's para 37 held that Miller's once purchase order is not issued, even if the LI stage that is not Miller's not treated as Miller's contract, Miller's. So here is there is no agreement has been executed, Miller's, and no award of work grant issued in favor of the petition of Miller's. So therefore, no agreement execute, no Miller's, no arbitration clause, general condition of terms and condition is not applicable. The Lordship will refer Miller's. The Lordship decided in Bharat Sanchar case also, your Lordship also referred in that case. Miller's, I have given judgment in your Lordship, written note of submission, Miller's. Your Lordship judgment. That is incur pharmacist.
This only point is this.
Yes, Miller.
All these arguments, the arbitrator will look into, he says.
Miller, in Probin Kumar case, Miller, there is a specifically defined that Miller contract of award is made, Miller. Probin Kumar judgment. What my learned friend is referring in first paragraph, Miller, page 671, Miller. I have not given that. The appellant was declared a L1 bidder in regard to the online tender and was awarded the work. Here there is a award of work, Miller. So this judgment is not applicable to this case, Miller.
It will depend. I don't want
Miller,
to.
it
will depend on the terms and conditions of each contract.
Your Lordship, see, Miller.
Kindly see.
Miller, here there is no Miller's, no contract is executed between the parties.
Yes.
So, my lords, I have given
Just
several
two
judgment, your
documents.
lordship,
Yes,
including
I've got
your lordship judgment, your lordship.
I've got.
Your lordship judgment in that MQ pharmaceuticals, that's what he's referring to.
Yes.
There's the clauses were not of this nature.
Right.
Now, what is key here, my lord may see two documents from the rejoinder, page 51, and it's a P28. May I just place that, my lord? These are
Yes.
the minutes of the board.
Yes.
Issue of letter of intimation, LOI, and award of work to the lowest bidder identified as setting up so and so. So and so the board deliberated on the subject in detail based on the facts brought out in the agenda note and clarification by so and approved the proposal as per the following. Then one, for intimating to the lowest bidder so and so, that is the petitioner, by issuing letter of intent by uploading the document in so and so, and for signing of contract. Then my lords may kindly see clause 2 is important. Award of work to the lowest bidder so and so after receipt of revised environmental clearance in accordance with the provisions of the bid document with the following terms and conditions. So this is the board document itself. Then my lords may see 2 pages thereafter. Page
No. I think here is the board having approved the proposal.
My lord.
This did not result in an actual issuance of such a award of work.
So this resulted in issuance of a LOI.
No. I think LOI must have already been issued by now.
LOI is not in dispute.
No. By this date, 11/2/2019.
Correct.
LOI had been already issued. 7th itself.
Yes.
7th February.
7th February.
So after 7th, this 11th happened.
After that, so award of already taken a decision. Clause 2. Clause 2 of those minutes.
Actually, the minutes is of 28th January.
Yes.
Right.
My lord.
LOI.
So they decided to issue both LOI as well as LOA.
My lords. Once LOA, the decision is there, then all that I have to show, my lords, is that I have an arguable case. So these documents would bring me in that category of an arguable case. My lords may see Praveen Electricals, the judgment of the Honorable Supreme Court. Then after this page 53, they have also awarded the contract. Page 53 of that.
He says in Praveen Electricals, there is an actual award of work.
Let us see para 18, what they have said. Paragraph 18.
Vidya Drolia.
The bench finally concluded in Vidya Drolia. Para 153 has been quoted. Accordingly, we hold that the expression existence of an arbitration agreement in section 11 of the Arbitration Act would include aspect of validity of arbitration agreement, albeit the court at the referral stage would apply the prima facie test on the basis of principles set out in this judgment. In cases of debatable and disputable facts and good reasonable arguable case, etc., the court would force the parties to abide by the arbitration agreement as the arbitral tribunal has primary jurisdiction and authority to decide the disputes, including the question of jurisdiction and non-arbitrability. Then my lord may kindly see para 19. On the next page, Ramanaji in a separate concurring opinion after referring to the case law summed up the conclusions as follows. Para 244, before we part, the conclusions are sections 8 and 11 of the Act have the same ambit with respect to judicial interference. Usually, subject matter arbitrability cannot be decided at the stage of section 8 or 11 of the Act unless it is clear case of deadwood. The court under sections 8 and 11 has to refer a matter to the arbitration or to appoint an arbitrator as the case may be, unless a party has established a prima facie summary findings, case of non-existence of valid arbitration agreement by summarily portraying a strong case that is entitled to such a finding. The court should refer a matter if the validity of the arbitration agreement cannot be determined on a prima facie basis, as laid down above. When in doubt, do refer. This expression, my lords, may kindly see.
The scope of the court to examine the prima facie validity of an arbitration agreement includes only whether the arbitration agreement was in writing or whether the arbitration agreement was contained in so and so, whether the core contractual ingredients for the arbitration agreement were fulfilled. Now, one more judgment of the Delhi High Court, which has been approved later on by the Supreme Court, my lords, may kindly. Para 33, my lord, just it's Mahindra Sustain. May I just place para 30? It has been made further clear that the dispute would be regarded as non-arbitrable at the section 811 stage only where the nature of dispute is ex facie non-arbitrable or where the dispute does not relate to the arbitration agreement. The situation has to be chalk and cheese or alternatively black and white without shades of gray. In all other cases, the section 11 court should follow the more conservative course of allowing the parties to have their say before the arbitral tribunal. Cases where the dispute is by law ex facie non-arbitrable would, for example, be criminal cases, cases involving exercise of sovereign power, cases which by statutory fiat are required to be determined by courts, cases in which cause of action is in rem or where the subject matter of dispute affects third party sovereignty. Approved by the Honorable Supreme Court. I'll just give that order now. It's not a case where the SLP was dismissed in limine. There has been some discussion. And what I'm trying to bring before my lords here is that this case has shades of gray. It's not something in black and white, particularly if pages 144 and 145 are seen. Order is reserved.
Only one document.
We have also got my lord orders from Delhi High Court.
Only one document.
Convenience.
Only one document. Your lordship see annexer J, page 796. I have cancelled the tender and refund the EMD amounts of 50 lakhs millers. And your lordship see your lordship order that I have given in my written note. Compilation. That it is a short order. May I read, Miller?
Yes.
It is only when the above efforts fails, the parties are agreed go for arbitration in crucial terms successful bidder and the dispute has to in connection with the relating to the contract. The contention of the petitioner is that successful bidder is based on the communication of 26th November 2018, which titled revised bidders and select rejection list. It is appear said communication through petitioner was identified as an auto-generated process the lowest bidders. It was in fact cancelled since the bidder was said to have been retail outlet, which is contrary to clause 5.2.1b of the tender documents. While learned counsel for the petitioner state that reason without basis in view of the rejection of the bid, petitioner cannot term as successful bidder. Here there is a Miller's tender already been cancelled and EMD already been refunded Miller. And in view of Miller's this order and as well as your lordship the judgment in MQ case Miller is not a bidder Miller. His contract has not executed Miller. And there is no agreement. Since there is no agreement, Pavin Kumar case is not applicable to this case.
Orders reserved. Here, my lord, that factual issue, I think we should be at fact agreement. We have been declared as successful bidder. Otherwise, I won't. I'll examine it. And that clause, my lord, that successful bidder is not defined anymore. Or I'll examine it. And my lord, there is a clause for these losses. We were kept waiting for 2 years. We have suffered losses of 140 crores all.
That's due to the Miller's Minister of
Anyway, sir.
notification.
I'm not in the minutes. Right.
Item number 10.
Item Miller's it is covered by Supreme Court.
My lord, my learned senior is heavily relying on a judgment of the Supreme Court, and my lord, exactly a similar matter is pending before your lordship, which is yet to be listed on 30th of September. I also
that day will deal with that, sir. Just the judgment.
My lord, filing an affidavit, additional affidavit, why will not be covered under this judgment?
Let's see that.
I'm also serving a copy on my learned.
already passed several orders in that regards. my lord.
Since
There.
another matter is pending for 30th September.
My
so-
lord, similar order are already.
Yes. That's okay, we'll.
In view of
Deal
the
with it.
Supreme Court order, your lordship already passed that.
My lord will cite some other judgments on, exactly the similar matter is pending for 30th September and the petitioner is also same. And
We pass the same order in that matter.
yes. My lord, let it come on 30th September. Both can be disposed of together with.
Doesn't make a difference, sir. Your case only, no, 30th September also.
Yes.
Then.
My lord, we're about to cite some other judgments also.
Do it right now, sir. You can't go on adjourning matters. Whatever you have to cite, please cite it.
Right now, I'm not.
No, I'm not going to adjourn like this, sir, please.
I've given that order, my lordship, your lordship order.
Counsel for the petitioner has filed an additional affidavit seeking to explain why the present case would not be covered. Judgment dated 25th July 2022 passed by the Supreme Court of India in civil appeal number 4914 of 2022 bracket Mahanadi Coalfields Limited versus Messrs. IV RCL AMR joint venture. Stop. The fact of the matter is that the clauses in the contract in the present case are no different from the contract invoked. Clauses invoked in the above judgment of the Supreme Court. There's a finding by the Supreme Court that those clauses do not constitute an arbitration agreement between the parties. Full stop. Having perused the additional affidavit, the court is not able to discern any distinguishing feature which will make the said judgment of the Supreme Court inapplicable in the facts of the present case.
My lord, may I just.
You may have to move the Supreme Court, sir, because according to you, the Supreme Court has wrongly decided.
No.
Yes,
My lord,
yes. You said they have suppressed some facts from the Supreme Court. And therefore Supreme Court has decided.
Yes, my lord.
So that is not for this court to decide, sir. That is for the Supreme Court to decide. According to the petitioner, certain facts were suppressed before the Supreme Court of India. This would only mean that, according to the petitioner, the judgment of the Supreme Court requires reconsideration. So that prayer obviously has to be made before the Supreme Court of India and not this court. For the aforementioned reasons, the court is of the view that the issue stands covered against the petition. The judgment of the Supreme Court in Mahanadi Coalfields Limited versus Messrs. IV RCL AMR joint venture. And consequently, the present petition is dismissed. It will nevertheless be open to the petitioner to seek other appropriate remedies as may be available to the petitioner in accordance with law.
Item 11.
At item 11, Mr. My learned friend begins. I have some personal difficulty. I have to attend one ritual, my lord, 11th day of one of my relatives.
All
Can it be
right. At the
taken
request
off?
of senior counsel for the opposite party. List on 28th October.
There is an arbitration clause.
I know.
There
No,
is a
that's
dispute.
correct.
There's a dispute, there's an arbitration clause.
No, there is, it's
But
barred by
again-
limitation. I will.
Limitation matter will also be gone by the arbitrator.
No,
not the-
that's correct, but there are direct judgments of the Supreme Court, recent
Right.
judgment.
We'll also take up this side of the vacation because
Desperately barred by limitation.
limitation issue.
No, that has been dealt with in innumerable judgments. The
This
recent
side of
judgment.
14th October.
Case is the recent judgment.
Because 30th, we already kept severance yet. So that's the last day before the occasion. That's right. Let it be on 28th. 28th October. Right.
Item number 12.
My please, your lordships, my lords, on the last occasion, my lord was pleased to issue notice in this case. The
AD
notice.
not back, sir. Oh, but confirmed.
Yes.
Anyone appearing for the other side? All right. Despite service of notice, none appears for the opposite party. What is the amount of claims, sir?
My lords, it's around 28 lakhs, my lords.
All right. SS Paddy, Mr. SS Paddy, counsel as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration set. All right.
Supplementary list item 13.
My lords, item 13, my lords, may give me 2 weeks time, my lords, I have to file my reply to application.
Counsel for the respondent, opposite party seeks and is granted 2 weeks to file reply to join up for the next date. 28th October.
My lord, I am also appearing for the OP1. I am filing in my Bhakra.
Okay. Item 13.
Yes, madam.
13.
Item
41. 41 up to 13. Serial 13.
Oh, sorry. I'm sorry.
Oh, I see.
I'm so sorry. I'm so
My
sorry.
lord,
But are you fixing the request for arbitration?
No, my lord, I am not, I have only yesterday I have received the brief, so I may be allowed for my time.
So when they give you a brief,
My lord. I have to oppose, my lord.
you have to oppose.
Yes, my lord.
Then you say that.
Yes.
All right. Counsel for the respondent, same thing. 28th.
Supplementary list item 14.
Sorry. My lords, item 14.
I am for the petitioner.
Yes.
Please, sir, I am appealing for the petitioner.
All right. He wants time. All right. No, he wants time for a reply. All right. Same order. 28th.
Grateful.
Special list. Specialist item number 1.
Already in this matter, the incident relates to about 30 years back now. The petition has been convicted under section 409 for realized offense under 409 for temporary misappropriation. The amount involved is only 13,000 some more. The penalty of 2 years and the fine of 1,500 rupees have been imposed, madam. Well,
modify the sentence.
No, that's what my submission. Without entering into merit, your lordship may dispose of its period undergone.
And you say for a conviction under section 409 IPC, just show me IPC. The petitioner has been sentenced by the trial court. No, but this you can't apply probation here also.
No, let's.
Imprisonment is a must, sir.
Imprisonment is a must.
Imprisonment is a must.
The
You can't modify the sentence.
Learned trial court kindly turn to page 38 of the trial court. Your lordship may kindly
38.
Page 38. Trial court. Categorically held that it is a case of temporary misappropriation because before the charge was framed, there is an exceptional reason, my lord. Why? And the learned trial court has gone into that aspect, saying that he may not deserve acquittal, but certainly that factor, because before the charge was framed, the entire amount of that 30,000 was deposited.
That makes it worse, isn't it?
My lord,
It's an admission then.
and I do consider. So therefore, since the amount of involvement considering the
you can't have an acquittal, sir. In fact, there's an admission.
My lord, that is why that is my humble submission as period undergone because the exceptional nature.
No, sir. The punishment is either imprisonment for life
or not,
or which will extend to 10 years.
My lord.
And what you've been sentenced to is 2 years.
2 years.
2 years, my lord.
So that is not and you are a bank employee.
No. He's a postmaster.
He's a postmaster.
Whatever. That's a even more responsible position, sir.
Postmaster, and there are several aspects. The question of entrustment.
Defense was Miller's that he had done it in coercion, but 14 pages he has written in his own handwriting. So the trial court has held that that does not show that there was any coercion. So the seized cash books and all, that has direct entries made by him in his handwriting.
So
Sorry, sir.
so in the exceptional
No.
fact of the case, my lord, because that
But this is not that kind of a case. All right. Dismissed, we'll pass the detail on. All right.
item number 2, period undergone, your lordship is considering all these matters like that because 30 years back the.
No, but it can't result in overlooking evidence, sir. Sorry. Yes.
Item number 2.
None appears dismissed on opposition.
Item number 3.
In this case, OP number 1 and 3 have died. I have taken substitution petition.
All that substitution is allowed. Yes.
My lord.
What is the matter about it?
Matter I have before my lord that the trial court has allowed the amendment petition which are all.
How is a writ petition maintainable, sir, for that?
My lord?
How is a writ petition maintainable for these things?
Previously it was filed.
I know.
After that CMP was filed. That is the difficulty. My lord, the amendment petition was allowed on all matters which is time barred. The other
that the court will look into. That the court will look into. If it is time barred, the court will decide that.
That in that event, may I pray that on that factor issue will be framed.
Yes, yes. You say it will be open to the petitioner to urge before the trial court that the issues which have been permitted to be raised by virtue of the amendment are time barred, and request the trial court to frame specific issues regarding the limitation aspect of the newly raised points by virtue of the amendment. With this clarification, the court declines to interfere with the impugned order of the trial court. The writ petition is dismissed. The interim order is vacated.
My lord, I am appealing for opposite parties.
All right. None appears dismissed on opposition. The interim order is vacated.
Specialist item number.
There is no interim order, my lord.
There is no interim order. All right. Dismissed. All right.
Item number 5.
None appears dismissed on opposition.
Specialist item number 6.
May I please your lordship? My lord, the application filed by the plaintiff under order 1 rule 10 was partly allowed and partly rejected in the impugned order, my lord. My lord, in a suit for partition, default number 3 and default number 5 have died, my lord. And an application under order 22 rule 4 sub rule 4 was filed because the default number 5 has not filed any written statement, and default number 3, though appeared, he has not taken part in the hearing. So an application under order 22 rule 4 sub rule 4 was filed, that was rejected. Then an application under order 1 rule 10 was filed to bring the LRs of default number 3 and default number 5 on record, my lord. The Honorable Trial Court in the impugned order, though allowed the application to bring the LRs of default number 5 on record, but refused to bring the LRs of default number 3 on record. That part order the order.
Why? What's the reason?
The reason your lordship may kindly see page 41 in the middle portion, my lord. That is running page of the
36, right?
page 41.
Yes.
In the earlier occasion, my lord, in the first line, in the earlier occasion, orders were passed refusing revocation of the abatement order.
So that's correct.
Passed against default number. My lord, I have given the Supreme Court decision, my lord, that it is Supreme Court 355, my lord. In a suit for partition, even if the order of abatement was filed, his passed, his alerts can be brought on record under order 1 rule 10, my lord.
Where is that?
My lord, that your lordship may kindly see.
$355 against the Rajasthan Honorable Court of Rajasthan High Court. This was a petition.
So this is on the peculiar facts of the case, sir.
Milord, similar is the situation. This is also a partition suit, Milord.
But there they said no prejudice is being going to cause.
Milord, here
It will delay the whole. What was there an interim order here?
yes, Milord, on 1/12/2011.
Have you served the other side?
Milord,
Just check. Hmm? The OPs are dead, sir.
Milord, the SR returned from OP number 1, 3 and 6, Milord.
And they're all dead.
Milord, that these three.
Then you not move for substitution.
Milord,
then-
one stage in the substitution will also amount to substitution. In all stages, I will file necessary application.
No, not this stage, sir.
Milord,
This report came when?
the report came in and it was never listed thereafter. Milord.
List is a separate issue, sir.
It has never been notified.
No.
Well, supposed to follow. Milord,
It's not privileged to come and intimate you everything, sir. We're supposed to follow.
Your lordship's office is not accessible to us, Milord. Because unless it is notified, Milord, the SR is not known to us, Milord.
Sir, what is that? You have to go and find out. You do an inspection of the file, you know what the position is. You don't wait for the court to intimate you.
Milord,
They've all been at the bar, sir.
Milord,
If you're the matter, the application to inspect the file, you will know what has happened. Process P filed.
when SR returned, Milord, immediately it is noted, Milord, that the SR returned because of non-service against some of the opposite parties, those are dead, Milord. Then only it was placed before the bench for us and we bound to take steps for substitution.
Suppose it's not like in this court, today it was listed after how many years?
Milord, it was in 2011, stay was granted, Milord.
No. So 2022. So for 11 years, we'll just sit back saying, whenever the matter comes up, that is the day I will be intimated. I will start moving from then.
Milord,
This is
only submitted the requirements, Milord, and we are not aware of the result of the service.
So give all liability in the bar. It is not that I find something and I go off to sleep. Whenever the matter is listed, whenever the court will tell me that day I wake up and I will start doing things that I'm supposed to do. It can't be like that. If I'm really keen in pursuing the matter, I will get the file, I will find out what has happened to the service report.
Because the service is made through the register, Milord, it was only reported, then only we came to learn about the report, Milord.
So today, if you have listed this matter, you have never known about it. Assuming it is listed after 20 years.
Milord,
After 20 years, I know that somebody is dead.
Milord, there was no occasion for us to.
The same argument is
The High Court rules, it is placed before the bench for us, Milord.
So I'm saying till that does not happen,
Miller.
you can conveniently say, sir, I am not aware.
Miller, unless the rules is changed, Miller, we cannot also know about the.
Rules do not prohibit you from finding out what has happened. No rule prohibits.
Rule says that it is to be reported, Miller. And it is to be.
The High Court will not permit inspection of a file by an advocate.
No, that's actually. Miller, the rule is that the moment it is returned, it is to be placed before the bench. Because the rules has to be followed scrupulously, Miller. In this case, it has not been listed, so there was no occasion for us to know.
Anyway, you will get a civil review of this matter. We vacate the stay. We'll vacate the stay because at this rate, now you will start hunting for the LRs, correct?
No, Miller. The question of hunting for it was only reported today, Miller.
Correct, sir. Mistake is only of the court. It's not of yours.
We never say it is a mistake of court.
You are very gracious.
Miller,
You are very gracious, sir. Very gracious. No difficulty. So today you come to know that some opposite parties are dead.
Yes, Miller.
So you have to find out the rules, and that is the High Court has to do. No, just to say, sir, I will do it. All right,
Miller.
How long will you take to do it?
Miller, next week you will also.
How do you know the names?
Miller, Miller, it is the matter from Cuttack, Miller. We can find out the name within 3 days. There is no difficulties, Miller. And the abatement will not in this writ petition, Miller, the law of substitution is not strictly followed, Miller. It is under the
nothing, sir. As long as your petition, nothing is to be followed. So there's no substantial justice what we're doing. This is making it a mockery, actually. People who died some 10, 11 years ago, today after 11 years, you will say only today at the High Court it was listed. Only today, so today I'm making an application. Do you think that when you file that application, we issue notice to his LRs, will it get served?
Miller, none of the opposite party also brought it to the notice of your lordship.
The dead people have to come.
Miller, under the rules, the opposite party are to intimate, Miller. Then only the role of an advocate comes in.
So what a waste of time. Just look at this complete sheer waste of time. And that suit is pending now.
Suit is pending.
Suit hasn't moved an inch. You are the defendant in the suit.
I was the plaintiff in the suit, Miller. Because of the non-substitution, I will have to suffer, Miller. That is why I am before.
So you are making a party suffer even more now.
Miller, I cannot say, Miller.
Yes. You are heaping misery on your party. Nothing. This suit cannot move an inch because of your own CRP here. And today, by resisting this disposal, you're postponing this by another 5 years. Your suit will get postponed by another 5 years.
Miller, it can be taken up immediately after my application for.
Look what has happened, sir. You got one suit stayed, correct?
Right, Miller.
And you never moved an inch to get this listed. You never moved an inch to get this listed, sir.
Unless the SR is reported, how can I know that every formalities has been completed, Miller? That is my.
Actually, sir, we come from different bars, but I'm finding this completely surprising. My client, I have filed a suit for my client. I must be interested in that suit reaching its destination. I am saying, sir, I'm telling my client, we have filed something in the High Court, sir, we'll get our own suit stayed. All right. And we got our own suit stayed. Then I'm telling my client, sir, we should all go to sleep. We should not be worried at all. Next 10 years, 15 years, the High Court may or may not list that writ petition. Whenever it is listed, we'll see, sir, don't worry, your suit will be kept pending. Is this justice to your own client?
No, Miller.
If I was the lawyer, you are a much wiser lawyer. Maybe I was not such a wise lawyer. What I used to do as a lawyer was file application for early hearing. I would say, sir, my own suit, I have got it stayed in the High Court. I need that suit. My client is pestering me. When is the suit going to get over? We used to file applications for early hearing.
That can only be taken up by your lordships when the service report is completed. Otherwise, not, Miller.
Does that rule prohibit you, sir? Show me one rule.
No, I don't know.
Entertained.
No, but it can be.
I have also been in the bank for some 30 years.
My lord, of course, my lord. Otherwise,
I find millions of applications.
right.
None of there is no such practice in this court. Whether it's a writ petition in a PI or anything, I ask people, they say, no. We mentioned memos were filed, but it was never listed.
My lord, I will bring to your lordship several cases, my lord, where the application were filed, but not been taken up.
See, in this you show me you filed once.
You said that, my lord, there was no move, my lord.
So you are very happy. So the result is you are very happy that your own suit for your own client, you got it stayed in the High Court. You don't want this matter to go an inch. I'm going to record this today because this is surprising for me. That a lawyer for whose client he filed the suit, that lawyer got it stayed, the suit stayed in the High Court. The lawyer is not interested in letting the matter proceed. Remarkable, sir. Remarkable. It is truly remarkable that the lawyer who stands before the court for the petitioner is the lawyer for the plaintiff who filed the suit in the trial court, while challenging an order of the trial court that declined an application for substitution of one of the defendants by the defendant's legal representatives. The petitioner got the suit itself stayed in this court more than 11 years ago. Full stop. The lawyer did not then make any effort to get this writ petition listed even once. Full stop. In the meanwhile, 3 of the opposite parties have expired. Full stop. The counsel for petitioner still insists that the stay should continue and that he should now be given the opportunity of bringing the LRs of the deceased opposite parties on record. Full stop. When it was put to the lawyer for the petitioner that this will interminably delay his own suit, the counsel of the petitioner is unfazed and insists that he will still want to substitute the opposite parties. Full stop. Faced with the situation, the court sees no justification in the stay order continuing, and the stay is hereby vacated. As and when the petitioner files an application for substitution, it will be considered on its merits. A copy of this order be sent to the trial court forthwith.
Item number 7.
The opposite party one. 7 the opposite party one is for opposite.
None appears to the petitioner. Dismissal non prosecution.
Specialist item number 8.
I'm for OP number 3.
None appears to the petitioner. Dismissal non prosecution. Is there any interim order here, sir?
No, notice was for admission and stay.
If there's any interim order, it's stated.
Item number 9.
Item 9, my lord, the application, plaintiff's application order 6 rule 17 has been rejected on 2 folds. One is after the trial has already been commenced, other is there is no due diligence has been shown in the petition. That is the reason. The background is that plaintiff has filed the suit for perpetual injunction. Defendant has filed the counterclaim and the issue has been framed. Plaintiff has filed an application not
in this court for all matters arising out of civil suits. Writ petitions are filed, is it?
Yes, sir. After 2002, my lord, lordship, earlier it was civil revision was filed. Subsequently, now writ petition bypass that. Yes. Now it is CMPs has filed in all the miscellaneous petitions before the lower courts.
No, but this is all writ petition.
That is also in the Article 227 only, not for that.
All right. Yes. What is the amendment you wanted?
Amendment, my lord, there is some development has been incorporated in the plain.
because the one RP case, a revenue petition is in file that has been allowed, directed the Tahsildar to correct the record of right. Some portion of the land has been reduced. It is 83 to reduce to 79.
No,
and
no,
50 to
which year, suit of which year, 2009?
Yes, my lord.
And the amendment was made
in the year 2000. That is in 2012, my lord. After that is WSN is filed, plenty was filed and
let's see the impugned order.
Yes, my lord. At page 20, annexure 3, my lord.
Yes.
The observation is at page, my lord, that page 29. Start and the findings is at page 30. Because of the proviso rider clause in order 6 rule 17. After commencement of trial, the application is not be entertained. The defendant has taken the plea that it is within my knowledge regarding that shortfall of the areas, and trial has
You did not have to wait for that long.
Yes, my lord.
The present petition has been filed challenging an order dated 19th May 2012, passed by the Civil Judge Junior Division, First Court, Cuttack. In an application,
I am appearing on behalf of the opposite parties.
all right, in an application filed in CS number 18 of 2009 under Order 6 Rule 17, seeking to amend the plate. Full stop. The amendment was sought 3 years after the filing of the suit, purportedly to bring on record certain typographical mistakes, some purported typographical mistake, and some important facts concerning the area of the land in question, which is being claimed by the plaintiff, public petitioner. Paragraph. The above amendment was resisted by the respondent defendant by pointing out that the facts pleaded by way of amendment were already within the knowledge of the petitioner, public plaintiff, and that the plaintiff need not have waited till the conclusion of the cross-examination, till the stage of cross-examination of the Amin, that is CW1, to file the amendment application, and that it would interminably delay the adjudication of the suit itself. Paragraph. The trial court has agreed with the defendant and rejected the application for amendment. Paragraph. Having heard learned counsel of the parties, the court is of the view that no error can be found in the impugned order of the trial court. Full stop. The case of the plaintiffs that was that he had purchased acre 0.83 decimal of land, whereas in the Hull ROR, it was recorded as acre 0.79. Full stop. The written statement, the counterclaim by the defendant, claiming that the defendant had purchased acre 0.50 decimal of land, but the vendor had in turn purchased only acre 0.49 decimal of land from her vendor, was filed on 7/9/2009 itself. The facts regarding the difference in measurement was known to the plaintiff in September 2009 itself. Full stop. However, the amendment application was moved only in 2012, more than 2 years later, in 2012. Full stop. Paragraph. In the circumstances, the decision of the trial court to disallow the amendment cannot be faulted with. Accordingly, the petition is dismissed, the interim order is vacated.
Specialist item number 10.
May I pray one line, my lord? This point make a lot time of war.
No, that will only add to complications.
Otherwise, my lord, the fact remains, the area will be shortfall for all times, and neither he will be get the said area nor I shall be get the area, because the difference is 4 decimal only.
Anyways, I'm not saying anything more. Yes.
10 man, not pressed man. I am from
Not pressed, dismissed. Right.
Item number 11.
Dismissed, none appears dismissed.
Item number 12.
Plus 12 millers is also not pressed.
Not pressed, dismissed.
Specialist item number 13.
None appears dismissed, non prosecution.
Specialist item number 14.
What is this 23? 1 minute. All right. None appears dismissed.
Item number 14.
None appears dismissed.
Both of specialist number 15.
15 may I please permitted to withdraw my receipt. Counsel to the petitioner seeks leave to withdraw his petition. Dismiss this withdraw.
Specialist item number 16.
None appears dismissed.
Specialist item number 17.
None appears dismissed.
Specialist item number 18.
None appears dismissed.
Specialist item 19.
May I please, your lords? My lord, this is a case of elopement, my lord. The present petitioner and the opposite partner too.
The 164 is there. There's a 164 statement, sir.
Yes, ma'am.
All right. The statement of the victim girl under section 164 CRPC is on record. Full stop.
Now they are residing.
It is stated that the girl and the petitioner are residing as husband and wife.
And I blessed with one male
And
child.
are blessed with the child. Full stop. In that view of the matter, just take from the prayer clause. GRPS number swords are hereby quashed. Right.
Obliged.
Item number 20.
None appears dismissed. Interim order for any vacated.
Specialist item number 21.
Item number 21, lost. Here we are challenging take cognizance order under section 15 of the Environment Act. In different areas of managed coalfield, we have filed several criminal applications, 482 applications. Your lordships, by order dated 26/8/2015, was pleased to dismiss all those applications. This one was. All right. Your lordship had stated that these things can be agitated. These points can be agitated, right, at the time of trial, correct, framing of charges, right.
In view of the order dated 26th August 2015, in criminal MC 74 of 2014, this petition was also dismissed in the same terms.
Specialist
Interim order is vacated.
Item 22.
Permitted to withdraw. Dismisses withdraw.
Specialist item 23.
Withdrawn.
Specialist item 24. Item 24.
None appears dismissed.
Specialist item 25.
My lord, item 25, my lord, this is the 138 NI Act proceeding, my lord. I pray kindly taken up next week. In the meanwhile,
They're not adjourning.
That's the status of the case, my lord.
It's all right.
That the proceeding in the year of 2008.
All right. Permitting the petitioner to urge all the points raised in the present petition. At the appropriate stage, the petition is disposed of. All right.
Specialist item 26.
None appears dismissed.
Item 12.
None appears dismissed.
Specialist item 28.
None appears dismissed.
Item number 29.
None appears dismissed.
Specialist item number 30.
I think the 29, there may be interim orders. 30. None appears. Yes.
I don't have any instruction. My name may be deleted.
All right. Name be deleted. Dismissed from non-prosecution. Right.
My
Item
name.
number
Yes.
31.
None appears dismissed.
Specialist item 32.
Same order.
Item
33
33.
also same order.
Specialist item 34.
My lordship, please, my lordship. Kind of next week, yes, file Mr.
None.
At any
Once
day.
the petitioner states he misplaces his file, dismiss the non-prosecution. As and when the file is being able to locate it,
At any
it will be
day.
open to him to revive the petition. Yes.
Specialist item 35.
May it please, my lord. Lordship, this has been filed for cancellation of NBW issued in 15. But we have received no instructions from our client.
No instructions dismissed. Right.
Good.
Specialist item 36.
The interim order.
My lord, the matter has become infructuous.
Infructuous dismissed.
Item number 37.
Withdrawn. Dismissed is withdrawn.
Specialist item 38.
Already acquitted, my lord.
Infructuous dismissed.
Item number 39.
None here, man, challenging the order of cognizance, my lord. But in the meantime, that we in the other trial, the court was already religion, already acquitted, my lord. I think that we surrender religion bail, my lord. First trial.
All right. Counsel for the petitioner is permitted to raise all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. The NBW. The petitioner, the interim order dated 12/7/2016 is extended till 30th October. 1st November 2022, on which date the petitioner will appear before the trial court. That is the SDJM Khurda in GR case number 436 of 2009. The petition is disposed of.
Specialist item 40.
None appears dismissed in opposition.
Item number 41.
None appears dismissed in opposition.
Item number 42.
No instruction.
No instructions dismissed.
Item number 43.
None appears dismissed in opposition.
Specialist item 44. Pursuant to your lordship direction, I have deposited the entire amount along with the interest, my lords.
All right,
With
notice returnable before the roster bench.
Yeah, my lord, previous occasion it was listed that notices issued, neither the AD nor the notices have been returned. That's what we
Fresh
want.
notice you take, sir.
Yeah, fresh
21st,
note. Fresh note.
21st November.
Fresh notice. The amount may be kept in a fixed deposit. Our check will be.
All right, the amount deposited be kept in a fixed deposit.
Invested.
That's already there.
No, it has invested, the check has come. It has go to the account section for investment.
Yeah, it should be, the amount should now be placed in a fixed deposit. Initially for a period of 1 year. And be kept renewed during the pendency of the petition of the appeal, sir.
Specialist item 45. Item 45.
None appears dismissed.
Item number 46.
46, my lord, all the petitioner 1 to 4 are the in-law family members of the opposite part number 2. And the order of cognizance challenged before your lordship. And the matrimonial dispute set that judgment passed in CP case number 113 of 2013. Already divorce of decree passed by the family judge, Jaipur, your lordship.
Where is that, sir? Unless you show us, we can't see it,
my lord. That
The decree.
No, is it a settlement or a judgment? See, unless it's a settlement, it's not a mutual divorce. What are you saying? Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed.
my lord, charge also not framed till now.
All right.
My lord, liberty.
Yes.
Specialist item 47.
Notice was issued, my lord, in the address which he has given in the FIR. Matter is not listed, my lords will permit me to take fresh notice.
All right, fresh notice returnable before the roster bench on 14 November.
They get 2 weeks time to ascertain the.
All right.
Item 48.
You see the fresh address being furnished to the registry within 2 weeks. Thereafter, notice returnable 14 November. All right.
Item number 48.
None appears to switch in opposition.
Item number 49.
Item 49 may appears. Item 49 may appears. The presentation is made because to quash and set aside the entire criminal proceeding in the previous petition. The FIR has been registered under section 420, which is annexed to 1. All the allegations against the accused number 4 minority. The bank has as the complainant has been sanctioned the main minority.
So, all right, so you raise all these pleas at the appropriate stage, permitting the petitioner to raise these pleas.
On page number 6 minority. Page number 6 mentioning no objection certificate properly issued at the bank minority.
All right, so you can show all this to the trial courts. All right.
Yes, please.
Item number 50.
Appears to switch in opposition.
Item 51.
None appears to switch in opposition.
Item number 52.
None appears to switch in opposition.
Item 53.
Please, my lord. My lords to raise all the pleas at the
permitting the petitioner to raise all the pleas at the appropriate stage. The petition is discussed.
Specialist item number 54.
My lord, this is for enhancement of the compensation of amount.
Permanent local adat.
My lord.
Yes.
All right. The parties will appear before the continuous local adat on 30th September. If no settlement is arrived at, list before the roster bench on 5th December. All right.
Item 55.
None appears to switch in opposition.
Specialist item 56.
None appears dismissed in opposition.
Specialist item 57,
No instructions. No instructions.
specialist item number 58,
None appears dismissed in opposition.
item number 59,
Pardon, Your Lordship. Your Lordship, this is a matter of 2015 and the earlier conducting counsel was my father. After his demise, the file could not be traced out.
All right. As and when the file is able to be traced out, the petitioner is
2 weeks
permitted to file the
time.
petition.
2
No,
weeks time.
whenever you find, you can file an application. Dismiss and opposition. Right.
specialist item 60,
None appears dismissed in opposition.
item 61,
None appears dismissed in opposition.
item number 62,
Same order. Dismiss and opposition.
item number 63,
Dismiss and opposition.
item number 64,
64, my lord, permitted to withdraw with a liberty to file to raise all the points.
Yeah, permitting the petitioner to raise all the points at the appropriate stage.
Obliged, my lord.
specialist item 65,
No instruction, my lord.
No instructions dismissed.
specialist item 66,
May I please, your lordship. Madam, in this case, notice was issued to the party who is the informant in this case. So far the noting is concerned, notice and the AD has not been.
So we'll permit you to raise all the pleas, sir. Permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
I don't know, may I say disposed of.
Disposed of leads. Yeah.
specialist item 67,
May I please, your lordship. No, this is quashing of criminal proceeding under section 138 on the ground that the company is not a made a party and the managing director is only the party.
You are the complainant.
I am for the complainant.
So this law settled, sir. Unless the company is proceeded against, you can't proceed only against the director.
My lord, see, the petitioner filed to drop the proceeding. The petitioner the accused filed the petition before the learned SDGM to drop the proceeding on the ground that because the company is not been made party. I might not go through the under section 141 of the NI Act. The learned SDGM has clearly reflected the provision in its order. Annexure.
Are you aware of the Supreme Court judgment? Anita Hada, have you heard of the judgment, sir?
No, provision is that the
sir, my question to you is, have you seen the Supreme Court judgment in Anita Hada versus Godfather Tours and Travels?
No, my lord.
That means very clearly that in a 138 NI Act proceeding, you cannot proceed against only a director if you do not make the company a party.
My lord, here is the director is the proprietor, that company is made by the director. And no other
settled legal position in Anita Hada versus Godfather Tours and Travels. That without proceeding against the company.
My lord, next week.
It is not possible for the complainant to proceed only against the director. I mean, permitted to case number so and so in all proceedings consequent thereto. I hear the question.
Man, permitted to are the company as party.
Not at this stage. No, sir, not at this stage. Yes.
item 68,
Yes. None appears dismissed in opposition.
69,
None appears dismissed in opposition.
item number 70,
None appears dismissed in opposition.
item 71,
None appears dismissed in opposition.
specialist item 72,
None appears dismissed in opposition.
item number 73,
None appears dismissed in opposition.
Item number 74.
Item 74, the petitioner is died on 18/2022.
What is the thing? I'm not understanding.
I am filing a memo with the death certificate.
Dropped. It is stated that the petitioner has died on 18 January 2022. In that view, the matter the petition is dismissed
I may be pardoned.
as having abated. Yes.
Your Lordship, my name is S. Ratha Miller. I am appearing for the opposite party. I am on virtual mode, Miller.
All right, sir. All right, sir.
Specialist item 75.
Honorable Mr. Pradhan, I pray next week because he is out of station, my lord. Yesterday night, he come to know that the list is.
What's the matter about, sir?
I have no power file with the Mr. Pradhan. Pradhan is an accommodation today. Your lordship, next week.
Just permit him to raise all the proceedings.
Because the interim order is here, your lordship.
That's all right.
Because
that's what happens. The other side is not here.
Because our list are published at night, your lordship. Therefore, he is filed accommodation that before that, my lord. Therefore, I pray next week because I'll be misunderstood by friend, my lord.
All right, at the request of counsel, the petitioner list next week.
Lordship.
Specialist item 76.
None appears dismissed in opposition.
Item number 77.
None appears dismissed in opposition.
Item 78.
For OP2, I am appearing, my lord.
None appears dismissed in opposition.
Item number 79.
No instruction, my lord.
No instructions dismissed. All right.
Number 80.
Permitting the petitioner to raise all the points. 85 also. All right. Thank you.
Item number 81.
None appears dismissed in opposition.
Item number 82.
82, my lord, in the meantime, petitioner number 1 has expired. So I pray, my lord, in respect of petitioner number 2, my lord, may be permitted to raise all the points.
All right. Petition number 1 has expired. Permitting petition number 2 to raise all the pleas available to him in accordance with law before the appropriate. Great. At the appropriate stage, the petition is disposed of. All right.
The order is applicable to us.
Anyway.
Specialist item 83.
No instructions, your lordship. No instructions dismissed.
Specialist item 84.
Permit the Lord to petitioner to raise all before the lower court.
All right. Permitting the petitioner to raise all, please.
Disposed of.
Right. Disposed.
Specialist item number 86.
None appears dismissed in opposition.
Specialist item 87.
May please, your lordships. The petitioner seeks to assail the order of cognizance, your lordships. The evidence
instruction.
It is 87, your lordships.
Lily Samal.
No, your lordships. Kumudini, I'm pardon, your lordship. I probably got the problem.
All right. 87, you say the memo is taken on record, dismisses not trust. Right. No instructions dismissed.
Item 88.
No instruction. No instructions dismissed. 89.
89.
Pardon, your lordships. The petitioner seeks to assail the order of cognizance, your lordships. Here, your lordships, the initial complaint was filed, and against that, a final report was put wherein the police said it's a mistake of fact. I have filed a date chart as well, your lordships.
So there must be a protest petition.
Yes. Protest petition cognizance has been taken. The fact is like this: the petitioner is she got married and then she filed for nativity or residential certificate. So after post marriage, she received that. On the basis of the nativity certificate, she got appointed as a staff nurse. Then the complainant filed a complaint stating that it is error and it is fraud has been practiced by the petitioner. On investigation, the person that they gave a report, which is also at your lordship will see it. I have annexed that, wherein they have said the nativity certificate is at page 39, whereas the report your lordship will find it at page 27. It is said that there was a nativity or residential certificate was issued, page 27, your lordships. It was issued, the certificate number, the first part I'm placing, your lordships, with reference to the subject cited above, and state that on verification of the miscase register 1998-1999, that is so and so, it is found that one Shri Kumudini Jenna, present petitioner, wife of so and so, has been granted residential certificate while miscase number 904 of 1998 instead of 9061 of 98. It is found that no such miscase 9061 of 98 has been instituted during the period of 1998. So, but the number certificate 904 of 98, but during the number it seems it's 9061. So my case in Lordship is that the criminal proceeding which has been instituted is a completely malified one. The complainant has initiated a number of criminal cases against the present petitioners. And this is one case wherein even though mistake was of fact, the FIR was lodged, the final report was forged on mistake of fact, because it is clearly evident that a residential certificate was issued.
All right. We say despite service of notice on the opposite party and some lawyer having appeared earlier, today none appears for opposite party number 2. The challenge in the present petition is to an order passed by the learned Judicial JMFC Bolangir. OC case number 32 of 2013 arising out of GR case number 680 of 2012 arising out of Bolangir PS case number 254 of 2012, taking cognizance of the offence under section 420.
No, Your Lordships, it is under section 468.
468 and 471 must be?
466, 468 and 471.
466, 468 and 471 IPC against the petitioner for allegedly producing a forged certificate. Paragraph. Initially on a complaint of opposite party number 2, a closure report had been filed by the prosecution, against which opposite party number 2 filed a protest petition. Stop. It is on the basis of the protest petition that the impugned order dated 25th August 2014 has been passed by the SDJM Bolangir, taking cognizance of the above offences against the petitioner. Paragraph. It's the report of the Tahsildar that there appears to be some overwriting in the registration number of the nativity certificate, as can be seen from the following narration.
Page 39 is the certificate.
No, in the letter dated 27th November 2012, addressed by the Tahsildar to the SI of Police, Town PS Bolangir. Reproduce that page 27. Paragraph. Therefore appears that there was indeed a case in which the certificate is issued, but only the miscase number appeared to be different. Full stop. The case itself was very old, and if in fact it might have been damaged by white ants, it cannot be said that the petitioner has deliberately produced a forged certificate, forged nativity certificate. But from that view of the matter, the impugned order taking cognizance is hereby set aside, and the criminal case against the petitioner, being I1CC case number so and so, is hereby quashed.
Obliged, Lordships.
Petition is disposed of. Right.
Item number 90.
None appears. Dismissal of prosecution.
Item 91.
None appears.
91, my lord. Trial not sought, my lord, after a puja vacation.
No. You file an application to revive it. You file the trial. The file is not raised, dismissed, with liberty to revive it if the file is traced. Right.
Item number 92.
My lord, item number 92. Pray for adjournment, my lord. There is some difficulties, my lord. My lord, S. Mahapatra engaged in state council, my lord. Till now he is not.
Let's see what the matter is about.
It is a matter of 306, my lord.
306.
Challenging the quashing cognizance order, my lord.
That's all. You can raise all these pleas at the appropriate station, permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. Stop. Interim order is vacated. The trial court will communicate this order forthwith. Right.
Item number 93.
None appears.
Item 19 resolution appearing before the opposite
That goes to the petitioner, dismissal, no prosecution.
Item 94. Yes, my lord. My lord, here, for the petitioner, my lord, here the petitioner is challenging the order dated 3/11/2015, wherein the learned court below has directed, while granting bail, has imposed certain condition to deposit 110,000 for payment, my lord. There is a offense under section, my lord. Here, my lord, under 130.
Sir, 130.
Yes, my lord.
So that's not unreasonable.
As directed to.
It's okay, so that's not unreasonable. Only the NBW can do.
Yes, my lord. Only.
You see, the interim order passed with this court on 10/12/2015 is continued till 1st November, on which date the
opposite party. In the meantime, there has been an amicable settlement out of the court between the parties.
Oh, I see. All right.
Yes, my lord.
All right.
I have no
Counsel
instruction.
for the opposite party informs the court that there has already been an out of court amicable settlement the dispute in that view of the matter. The infirmed order dated 3rd November 2015, passed in criminal appeal number 44 of 2015 is hereby set aside and the petition is disposed of.
Specialist item 95.
None appears, dismissal, no opposition.
Item number 96.
None appears, dismissal, no opposition.
Item 97. Sorry, 96.
96.
96. 96.
My lord, this is a case, my lord, a very peculiar case. What has happened? The petitioner, number one, is the wife of the opposite party. The opposite party has filed an application under 13(1) of Hindu Marriage Act at Bhubaneswar. The petitioner filed a transfer petition in Supreme Court to transfer the case to Visakhapatnam, Vizag. There, the opposite party appeared and contested also. In the Supreme Court, it is alleged that she has made a wrong statement. The petitioner made a wrong statement that the opposite party also stays at. The opposite party appeared before the Supreme Court and raised this objection. Supreme Court, in spite of that objection, transferred the case to the Vizag and the case was disposed of. Thereafter, the opposite party files an application, a complaint before the Bhubaneswar STJM saying that I have made a false statement in Delhi. So on that basis, a cognizance was taken. In the meantime, my lord, there's a lot of developments from 2018. Both are staying together at Bhubaneswar.
Let me file an affidavit, sir. Best is to file an affidavit and then we quash it. Then.
That's right. That's right.
Mr. Rao says that he'll file an affidavit to the effect that both parties are now staying together. List on 14th October.
Item 97.
May I please your lordship? I am on a VC matter. May I please your lordship?
Yes, yes.
This is a case, my lord, where cognizance has been taken against these two petitions and along with others, my lord, for commission of offence punishable under section 381, 379, 414. Allegation, my lord, these two poor boys, my lord, they were guarded in a milk plant, and some milk packets, my lord, polythene packets, was found to be transported. And thereafter, my lord, the staffs who were in night duty, no evidence, man, nothing to connect them, who were in night duty.
So what does, we'll permit you to raise all the pleas, sir. Permitting the petition.
One thing, my lord, one sentence, my lord. The co-accused persons have been, my lord, they have faced trial and they have been acquitted.
So it will become easier for you, sir. It will become easier.
Your lordship, we are not on bail, my lord, we are court.
It's all right. Permitting the petitioners to raise the pleas at the appropriate stage.
At the time of framing charge, my lord?
Yeah, you see the stay against the NBW will continue till 1st November, on which date the petitioners will appear before the JMC Jaipur in GR case number 434 of 2008. Yes. All right.
May I pray, my lord, one thing, my lord, In the meantime, co-accused persons have been acquitted. That will also.
No, that you can raise there, sir. You can tell the court that. Right.
Mention that.
I can only say you have made that submission. That's all.
Yes, ma'am. Yes.
You say first line. You say Mr. Nayak, senior counsel, the petitioner states that 2 accused have already been acquitted, and then this order was all right.
Item 98.
None appears. This was not possible.
Item 99.
No, please, Your Lordship. Here the present petitioner is challenging the order of cognizance by the London court below in a complaint case, my lord, under alleged offence under section 341, 323, 379, 506. The background of the case is that, my lord, the present petitioner is an outsider, is a resident of Chhattisgarh, my lord, and the complainant is a resident of the jurisdiction where the London magistrate has exercised the jurisdiction. As per the 482 application is filed only for the purpose that section 202 inquiry mandates that if the accused is a outsider, then certain procedure has to be followed by the magistrate, which has not been done in the instant case, my lord. The 202, Your Lordship, I'll apprise to, if Your Lordship will permit, any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made to him under section 192 may, if it thinks fit, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made under 156(3), my lord. So, but in the instance, my case is that, my lord, the petitioner and opposite, the informant, they are contesting a commercial dispute 138 case in Chhattisgarh. In order to avoid as a counter blast, he has filed this instant.
Who's appearing for the other side?
My lord, the notice was issued. 19.
There are 4 opposite parties, sir.
No, my lord. 99, only one opposite party. That is CRMC 344.
Satyavadi Sahu.
No, my lord, this is.
This is the wrong thing.
No, no.
The wrong thing.
This Dinesh Kumar Agarwal.
No, wrong thing.
That was 98, sir.
98.
98, who's appearing for the other side?
90.
Raj Kishore Monty. Swine, sorry, Raj Kishore Swine. And PK Monty. Durga Charan Lenka. Informant is in Sonpur.
Informant is of Sonpur. He, due to the commercial transactions, he has issued a check to the present petitioner, which was presented in Chhattisgarh, arising out of the 138 case. He didn't appear in the Chhattisgarh case, whereas he has filed this instant application on a complaint case filed in the R. Rampur. And although the allegation prima facie, so far as the 307 and other offences found, it has to go back.
The cognizance order can be set aside, it can go back.
Yes, my lord.
All right. None appears for opposite party number 2 complainant, despite service and despite counsel having uttered appearance on earlier occasion. Paragraph. The short ground on which the petitioner, who is a resident of Chhattisgarh, seeks to challenge the order dated 4 July 2015 passed by the JMFC S. Rampur in 1cc number, case number 5 of 2015 is that cognizance is taken against a person residing outside the jurisdiction of the court without following section 202 CRPC. Paragraph. With there being no opposition to the present averment, the averment of the present petition, the court proceeds on the basis that the averments are true and accordingly sets aside the order dated 4 July 2015 and directs that the JMFC S. Rampur will now proceed in 1cc case number 2015 afresh after complying with the requirements of section 202 CRPC. The case now be listed before that court on 14th November 2022 for being proceeded in accordance with law.
Item number 99.
None appears dismissed in opposition.
Item number 100.
None appears dismissed in opposition.
I may be excused, with lordship permission, my lord. that item 20 millets. I could not come, my lord, in time. I'm sorry, my lord, but I may be excused for that. The matter may be taken up so that what's the matter about? But family matter, my lord, challenge order of passing, my lord.
Permit you to take all the pleas, sir. Permitting the petition to raise all the pleas at the appropriate in the trial.
But I have also filed a stay petition because my lord, proceeding is going on there. Passing petition is also father-in-law, mother-in-law, my lord.
It's all right. Once you settle all that will go. In matrimony matters, without settlement, we can't quash the problem.
The divorce petition is filed, everything has been filed, my lord.
That's right.
I will also amnesty my lord.
The state parties to settle.
Satisfied, lordship, every document I filed.
No. Not inclined to.
I don't know.
Permitting the petitioner to raise all pleas at the appropriate stage. All right.
May I pardon your lordship, item note 65,
Ha.
may I be allowed to withdraw the case?
All right. 65 dismisses withdraw. Right.
Wording non-appears, my lord, may be deleted from item number 20 minutes.
Right. Hmm.
Pranam, sir, pranam.
Supplementary list for orders, item number 1.
May I please, notes on behalf of Mr. Patnaik, my lords, may I be permitted to submit notes. I filed this miscase, my lord, if the lordship would kindly turn to page 2 of my miscase application. Order dated 18/11/2003 minutes.
Right.
Although your lordship with the whole order, your lordship may kindly turn over the page to page 3.
Yes.
The operative portion is in the meanwhile.
Yes.
The tax, if any, paid by the petitioner will be without prejudice to the rights and contentions of the petitioner in the writ petition. And in case the petitioner succeeds in the writ petition, tax paid by the petitioner shall be refunded with interest applicable to fixed deposits. Now, the whole batch of writ petitions were before your lordships, and it was disposed of on 10/4/2019. Of course, your lordships have granted interest at paragraph, but that is a default interest, my lord. And my only prayer, my lord, is in addition to this default interest, the interest which was made subject matter to my deposits, my lord, on payment of all this may also be indicated, my lord. That's my humble prayer, my lords. Because
some matters pending in Supreme Court probably.
no, those matters are pending. In those matters, what your lordships have directed, my lord, is all these directions will be subject to the result of the writ petition, my lords. I'm sorry, to the civil appeals pending before the Honorable Supreme Court, my lords. The state has gone.
He was making some mention, some cases in similar matters. We have adjourned those matters to be taken up after the appeals court decision.
Very good, my lords. All right, because your lordships have already directed that particular direction is lacking in the main judgment itself, even though there's a default interest. The last paragraph of the judgment may kindly be produced, my lords.
But if this judgment itself is pending in the Supreme Court, then why you say since the especially petitions filed against the
civil appeals,
civil appeals. Okay. Have been since civil appeals filed against the judgment dated 10th April 2019 of this court are stated to be pending. The present application is adjourned sine die with liberty to the parties to mention it for listing after the disposal of the appeals in the Supreme Court.
Greatly obliged.
It's also same man.
Item number.
Your lordship, item number 2, I may be permitted from VC, your lordship.
Yes.
Your lordship might have remembered in identical matters, your lordship has modified the order, and against that order, your lordship, the department has gone to Honorable Supreme Court, and SLP, the order has been stayed, your lordship. That interest a bunch of cases, your lordship.
Correct. Yeah, you say list this application. No, parties are permitted to mention the present application for listing after the disposal of the fees in the Supreme Court. Right.
Item number 3.
May I, lordship. And last topic, lordship directed to State Council to obtain instruction regarding antecedent. The appellant is in custody.
My lord, we have called for antecedent, my lord, we have not received. We have called for the antecedent on 9 September 2022, my lord. We are yet to receive. Nevertheless, my lord, it's a criminal appeal. POCSO Act is their age. 10 years old child has been raped and murdered, my lord. So
Yesterday probably Honorable Appeals Court said wherever 10 years already completed may be released.
I know.
Last, yesterday's Supreme Court case.
But then
There was a bit more sort of.
gravity has to be seen to. What do you say? 10 years are complete here.
My lord,
9.5 months.
9.5. So you wait for 6 months. You say this application be. This is 361 or 22.
361
yes,
You say the court is not inclined to entertain the application at this stage. The court is, however, prepared to expedite the hearing of the criminal appeal itself. List for final hearing. Paper books are ready, right?
no, my lord.
Papers will be prepared and supplied to the parties within 8 weeks. List for final hearing on 17th January before the roster bench. In the event the appeal is unable to be taken up for hearing, then the present application can be considered.
Replacement.
Supplementary list item note 4.
Dismissed for default, restoration of.
All right. The order is recalled and writ petition civil 22072 of 2020 is restored to the file of the roster bench to be listed there on 14 November. All right. Right, sir. Right, sir. Thank you. This is Rahul. Namaskar, sir. Namaskar.
Supplementary list for orders item number 1.
Well, this matter, actually, the review application is to be taken up. The reason being, well, like the review, the REIT application, the Tata Steel was not made a party. And the order has been passed against them. We came to know after the ADM communicated the order to us. So we immediately filed one REIT applications, also a review application. So if you lordship accept the review application first.
Yes.
So I should be given an opportunity to contest the REIT application where I was not party. If you lordship looks at the cost title of the REIT application itself.
Right.
There actually was not made a party at page 77. They have only imputed the state police,
right.
ADM and land acquisition collector.
Yes, they are not parties.
The entire order, if you are seeing the affirmative.
So who's for the petitioner?
When I filed content with them, when my order officer was not compliant. So it's content matter to read that. Sorry, it's review.
Correct.
It's not a, it's notice or I do not know.
Sorry?
But I am for the petitioner.
No, but
content. My content is scheduled today.
no, madam, how can you ask for reliefs without making the review petitioner a party?
My lord, they're not the party, not required, my lord, because I have made the state government is a party. Those who are.
No, but the land is acquired for them.
My lord.
They are the beneficiary.
Each right they are directly affected.
My lord, when they were not made party, there is no whisper that they should be made party. The government was appearing and government side.
No. You should be aware for whose benefit the land is acquired. They should be heard. This very basic principle.
So every paragraph indicates Tata Steel.
State government acquired land for the Tata company.
Correct.
But we are the beneficiaries.
No, you are the beneficiary. They are the beneficiary of the acquisition.
Your land is active.
My
they are the beneficiary of the acquisition.
Your lordship is not, which is the contempt has been filed. The order says, my lord, after hearing the state government, they have not stated anything about Tata company.
That's not the point, madam.
My lord.
You see,
my lord, first 3 rounds I have gone. 2 REIT petition and contempt.
We'll make it time bound. What else can we do? We'll make it time bound. We'll make the REIT petition time bound.
That is better.
It will be reviewed. You say, challenge the present petition. The present petition has been filed by Tata Steel Limited, seeking review of the judgment dated 11th February 2020, asked by this court in writ petition civil 5277 of 2017. The said writ petition was filed by
Opposite.
Bhaiga Hydro alias Munda, challenging an order dated 9th December 2016, passed by the Additional District Magistrate Kalinganagar Jajpur. Turning down the representation of the petitioner to be included in the list of beneficiaries, correct?
Yes.
But under the rehabilitation policy.
Yes, my lord. Rehabilitation.
That is applicable to me, my lord.
That's right. 1 minute.
That was the prayer of the.
Yeah,
That was
Yes.
the prayer.
under the rehabilitation policy paragraph. The land that has been acquired is for the benefit of the present review petitioner. And therefore, it was necessary for the present review petitioner to have actually been heard, made a party and heard in the writ petition. Full stop. However, for the reasons best known to the writ petitioner, the present review petitioner, that is Tata Steel Limited, was not made a party. Full stop. This court which heard the petition, the attention of this court which heard the petition was not drawn to this fact. Although the impugned order was sought records this fact in para.
But para 6, I have indicated in my review application, order dated 11/2/2020, the operative portion.
My lord, I have not received a copy from the review petition also. They have filed a review petition, they must have to serve copy on me.
Why have you not given copy, Mr. Mishra?
Madam, you waited still now till I'm dictating the order to say this. You've been arguing without telling us that you don't have a copy of the petition.
No, on in review application, my lord. If they want, I can serve a copy.
Do you really want to file a counter to this review petition? The same order will be passed after all that.
Sorry.
We can ask him to give you a copy right now.
Yes, yes, my lord. Give him copy.
Accordingly, the order and review is hereby recalled, and writ petition civil 5277 of 2017 is restored to the file of the court to be listed before the roster bench.
On, there is another writ petition, I think.
Yes.
18966. That may be tagged. There is another writ petition, 18966 of 2020.
So the ADM passed an order on the basis of this order. Therefore, this writ application has been filed. So once the original order goes by, the consequential order has to also go.
Right.
That has to be tagged because that has to be disposed.
21st November. What is the consequential writ petition?
If your lordship looks at the order of the ADM, which has been communicated at page 28. Right, page 28, no. Sorry. Retro. Page 148. Of the read 18966.
You say in petition civil 18966 of 2020, in view of the order passed today, recalling the
at page 1
order passed in petition civil 5277 2017, the impugned order of the ADM dated 8 June 2020.
8/6/2020.
18 or 8/6? 8 June 2020 is hereby set aside. The writ petition is disposed of. What about this contempt?
There is contempt. That is also
disposed of. In view of the order passed in review petition. Contempt civil 526 of 2021 is disposed of. In the review petition, it's restored to the file. Tata Steel Limited will be included candidates opposite party number 4 in the writ petition, and the amended cost title will be filed within a week in the said writ petition. All right. All right.
Disposable.
Namaskar, sir.
For orders item number 1.
My lord, due to non-reval defect, my lord, the writ petition, my lord, due to some service of copy to the AG, my lord. That's my lord, so I have already thereafter served, and after going through the defect, my lord, defect number 6, my lord.
8 to 19.
My lord.
Yes.
My lord.
What is the defect?
Defect not to service copy to the state, any contempt petition. My lord,
what does the contempt petition survive?
Yes, my lord, survive. My lord, there is the direction to give the return dues.
So, can you find out where the
Yes, my lord.
you have served a copy?
Yes.
I have already served.
The contempt petition, sir.
Monty acknowledges that the contempt petition has been served. Copy to contempt petition now been served. In that way, the matter, the order dated 8/2/2019 is hereby recalled. And contempt civil 9/72/2017 is restored to file.
My lord.
And will be restored listed before the roster bench on 21st November. All right.
Item number 2.
My lord. Obligement.
Already, your lordship has filed the similar order dismissing the review. And that has been confirmed before the apex. Apex court that confirmed have given the order.
Oh, I see.
My lord has
Yes.
dismissed thereafter.
All right.
Apex court matter is connected review application, my lord. Matter arrangement same matter.
It has been already been confirmed by Honorable Apex Court.
Yes. All right. In view of the order dated 4/2/2022 passed by this court in review petition number 65/2021, which stands affirmed by the Supreme Court by its order dated 18 July 2022 in SLP Civil Diary number 9477 of 22. This review petition is dismissed.
Item number 3.
Item number 3.
3 may please.
Similar matter, lordship. Same order, same order.
Matters relating to the benefit of in respect of the resource teachers, I am drawing your lordship's kind attention. And I have also given the bunch of these documents for perusal Mahapatra also. But here I want to bring your lordships with regard to the claim of the resource teachers and divergent view of the similar coordinate bench. So, this honorable court division bench, one case, this honorable court division bench held that the judgment in case of dancing is not applicable, and the benefit of regularization was granted in favor of the teachers who were initially appointed under a centrally sponsored scheme and subsequently appointed by the state government upon closure of that scheme. And in another case also, the division bench of this honorable court held that in view of the fact that they were appointed under a centrally sponsored scheme and in view of the decision of the Honorable Supreme Court, and this is a schematic appointment, so that from the
only question is with regard to seniority.
My lord,
everything, protection and pensional benefit, everything has been dealt with in case of that dancing decision. Dancing decision is very small decision, but that deal with the exact issue involved in the present.
That has been discussed, my lord, in
notice.
I have given the order.
Why I am bringing your lordship's notice? Your lordship may take a decision as to the future. In this review, we have it to Supreme Court, and in the Supreme Court, we the SLP were withdrawn because in earlier occasion, liberty was granted for filing of review petition Your lordships have allowed those review petitions. Out of those review petitions, the concerned review petitions were being heard. I am saying, please, the concerned review petitions were heard and a different view has been taken. Here we have also withdrawn the review petition before the Honorable Supreme Court with liberty to approach your lordships for review of that order.
No, in this case, they are now calling out, say, I'm getting in item 3.
Yes.
Was liberty granted to you to file a review petition?
Yes.
Exactly.
Exactly. Yes. Here is the case,
You
my
have
lord.
never been granted leave and there is a delay also in filing the review petition.
My lord. Here is the case, my lord. Some liberty does case review, liberty is not granted. That is the case.
Exactly.
Exactly.
No, in
This case, your lordship will, that order is at,
Annexure 4.
yes, my lord. Page 21, my lord.
with no liberty, my lord. Yes. Okay, with no liberty to come back again to this court.
Oh, my lord.
I see.
With no liberty.
No Supreme Court.
The High Court.
Because I have supplied the other copy of the
This is with liberty, sir. Well, they want to seek a remedy before I will file a review petition. Dismiss a written term after no liberty to come back. Well, come back to this court, sir. Well, Supreme Court. My submission is there is a common order tribunal in 4 common order. 6 cases and calculated together. 3 cases SLP dismissed. So all the dismissed. Reproduction court. Conference tribunal. The order this one is the conference calculated on state. 3 SLP dismissed. And they are giving the benefits. All giving the conclusions. But if the Supreme Court is going to
Monday. The judgments are, sorry, on Tuesday, the judgments are pronounced in respect of the cases where this honorable division of this honorable granted liberty to file review before the Lord Tribunal and file a review upon transfer of those applications that those matters were taken up by unknown single judge allowed our review.
That case, that is Lordship dismissed all the petitions. They can Supreme Court 3 dismissed. 3 were remanded. Either 3 dismissed court. 12 division bench. And 3 cases they are giving the benefits. And they once they are complaining
I said that our review petition, when our review petition was dismissed without liberty. So there was no estimation. We call the order estimate. The petition. And the problem is not the law retired since 2020. My assumption is scope of review. I can scope of review matter. Scope of review, that I'll give him. But once they are the order of tribunal complete these particular 4 complete facilities, can be distinct among the these 3 are there any orders of ours allowing review petitions? Yes, I have given that review petition 22 of 2021.
That was allowed again. Dismissed.
That's why I am saying that
Let it go for the rest of them. So let's see what the rest of us does.
My lord.
You say, in view of the order passed by the Supreme Court in 19th, in view of the liberty granted by the Supreme Court in its order dated 19th April 2021, in SLP Civil Diary number 25,000 of 2020, permitting the state of Orissa to file a review petition in this court, and having heard counsel the parties, the court recalls the order dated 21st August 2019 and restores writ petition civil 3826 2019 to the roster bench of this court, where it will be listed on 21st November 2022.
May I the connected writ petitions, the honors of which I am citing, your lordship may say that all those writ petitions be tagged.
No.
Because I am
I can bring that notice, you can tell the. Nothing says October vacations, all right. Yes, ma'am. November is fine, right. That is problem. And so I will make a difference, so then that's October, November, right.
Item number 4.
My lord. Here, my lord, the order dated 12/12/2019. Limitation is there, my lord. I have filed a petition under section 5 of the Limitation Act for condemnation of delay. My lord, only the ground in the limitation petition I have taken. Do you know what is the matter about, sir? My lord, matter about relating to appointment of teacher. However, only paragraph 5, your lordship may kindly see, that will be clear of my case. Page 3, paragraph 5. That the school in question was taken over by the government during 91 as per the government resolution number so and so. Similarly situated teachers. This is my case, my lord. One Dasarathi and other one is Kunjo Bihari Sahu. Their appointment have been approved. But my lord, I have been working since long. My post has not been approved.
Sir, please tell us what is.
My lord, those things I have not placed, and that was not in the judgment. I want to, my lord, only another chance to be given you for a hearing.
No, can't do. That's not a ground for review, sir. That's not a ground for review.
My lord,
these facts are known to you and you didn't place it, so that's not a ground for review, sir.
exactly.
The delays condone.
Otherwise, my lord, I pray only, liberty may be granted to approach the appropriate authority. That your lordship cannot. No, poor teacher, my lord, due to COVID pandemic, my lord. So only you can go to Supreme Court.
You can go to the Supreme Court.
No, my lord, if the lordship grant me liberty,
Litigation, sir. Sorry. It will only start another round of litigation to not solve anything. Yes, you say the no ground made for review. Sorry. Yes.
This page. Next one.
Right, sir. Namaskar.
Sir, pranam, sir.
Pranam, sir. Pranam.
Supplementary list for orders, item number 1.
May I please, Your Lordship? Yes, this petition is for recalling the order dated 17/8/2021, dismissing the writ petition for non-prosecution. The reasons have been stated in para 5.
All right, for the reason stated there in the orders recalled, is this issue allowed, sir, this in the writ petition?
Yes, my lord.
All right. Writ petition civil 7616 of 2010 is restored to the file of the single judge of the court. Will be listed before the roster bench on 21st November. All right.
Item 2.
My lord, this is an IFR amendment in the same writ petition. My lord,
this will be listed with the main case, sir.
Yes, ma'am. Yes.
This application will be listed along with the main case on the same date. Right.
Obliged.
Item number 3.
That is to be self-leak.
The correction. Yeah. All right. The office note has been produced. The correction will be carried out as indicated.
Item number 4.
Item number 4, my
Item
lord.
3, copy may be served.
All right.
Item number 4, my lord. The steel authority, the petitioner, my lord. We have filed an application for extension of time. In terms of your lordship's order, we have already shifted the machineries. Only technical difficulty, only once of time to hand over the land. And in this regard, we have also submitted an application to the opposite party number 1, seeking time. Only for
what's your instructions, sir?
Lord, para 3, we have already stated, we have already shifted the machineries.
That I have to get instruction because current position, current status, I am not aware.
I see. All right.
No, if he is saying that he has.
Yeah. He just wants extension of time to hand over.
Extension may be given to the petitioner.
All right. The time for handing over the land stands extended up to 30th November. 6 months. Till 31st December 2022. All right. The application is disposed of.
Item number 5.
Yes, sir.
The appellant has not yet surrendered. Still in parole, enjoying the parole. Parole is being extended, but I cannot do anything.
That's right. It is stated that the applicant is still on parole.
It has been extended last till 1st of November 2020.
I see. So we'll have it on 11th November, sir. 11th November.
Item number
11th November.
Any respectful submission is. Your lordship should hear the cause of the matter.
I know, we'll do it next time, sir. 11th November. All right.
Item number 5, my lords. Criminal appeal number 649 of 2019. I was directed to get that report. Yes. I will get the order. Yes, sir. 14/5/2025. Achhe se order. No, I will get the report. I'm sorry. Order copies. Item number 6.
Item 6 is a disposal of matter wherein state filed a IA for clarification regarding a direction to the petitioner to pay the demanded dues. That is that the dues is already under challenge in another writ petition. That is WPC 39269 of 2021.
Which is listed along with that.
So this has become infructuous one.
So I will become infructuous. I will disposed of as having become infructuous. All right. Item number 7. I like this case file, dismissed or default. This is a restoration petition, my lord. All right, but I was disposed of for delay. CMP, the order is recalled in 192-298. Is restored to the file of the division bench. To be listed on 28th November.
Sir, Pranam.
Pranam, sir. Pranam. Patnaik.
Yes, sir. May I please, your lordship?
Yes.
He's here. May I please, my lords? My lord, on the basis of my lord, both of us were there, but in the meantime, during the pendency of the writ petition, the worker was engaged by the bank through proper channel, my lord. So accordingly, we said that it might become, at least become infructuous. All right. To that, my lord. He filed an application before saying that I am entitled to get, because the tribunal directed to pay 50,000 compensation, my lord. The lordship may kindly turn to page 2 of my application. I quoted the tribunal's order, my lord. Right. Paragraph 2. In view of the discussions made above, the management is directed to absorb the work as an award staff with national benefit of such and with other have been regularized or circuit such and such with compensation consolidated 50,000 towards back wages and litigation expenses calculated on an average basis. Admittedly, this was not paid. Reason being, my lord, it is one year we compared the 17B. In the next page 9, I also may look at. He gave me that I shall withdraw the cases and all that if I am given employment. So thereafter he worked for quite some time with the bank. Now he is retired and getting pension. So this being so, he files an application, you pay my arrear dues. That is why before my lords, to rehear the matter. But in the meantime, he was also suggesting if your lordship without recording our concession that 50,000 with some interest we can pay to him. Provided the lordship directs. This is not, I am not saying so. I am not conceding to that, your lordship. Literally 50,000 remains to be paid.
This IA has been filed by management seeking clarification of the order dated 15th February 2022 passed in repetition civil 18057 of 2008, whereby the court had recorded that the matter had been rendered infructuous. It is stated that an order had been passed by the tribunal requiring the management to pay the workman rupees 50,000. Which page is that? That's part of page 2 of my
petition, my lord, has quoted the order. Consolidated composition is 50,000 as back wages and litigation expenses. Full stop. It is this amount that is being demanded by the workman who has superannuated. Full stop. Having considered the pleas of the parties, counsel of the parties, the court directs that the aforementioned sum of rupees 50,000 shall be paid by the management bank to the workman. To do it simply, it is at 6% per annum. From 15th July 2008, 15th July 2008, 15th July 2008, till the date of payment. Right. Till the date of balance, till the date of payment. Will also make it consolidated 1 lakh otherwise also. In the date of payment, it shall not be, I think, yes, my lord, it's today, right? And in this year also disputes between the parties comes to an end. It is understood by the parties that with this, there will be no further claims for the workmen against the management. Right. Item number 2. May it please your lordship. And your lordship rightly remembered the matter to the sub-collector in taking up the matter from Monday onwards, my lord. My lord, your lordship is granted liberty to the petitioner to address the sub-collector, and we also intervened 16 numbers covered on the particular. Who said some intervention petitioner there? One order to be passed, my lord, that is filed only at the instance of 49. There the villagers under 2 sets they are filed. 1 set has been allowed. The other set is in this case 1711 They will allow to participate in this.
My long friend is creating a mess. If another 49 people will go,
that's some files subsequently because of the penalty, my lord. 1 set came and we are 16 day file, 2 years later they file, my lord. We just made solutions, my lord. So the other persons will be right. Sons, my lord. Submissions. When you file there, submissions. Yes, yes, that is the now, in this case, 1/7, August 2020 to this limited extent. The I is disposed of. Now, in this case, 1/7,115. Item number 3, 49%. Yes.
Your lordship directed me to make representation for allotment of alternative land instead of alternative land in the land in question. You can running school. This will be only modification.
That's a review. There is no deadline to modify the application is dismissed. Sorry. Yes.
Yeah, the school is a running school.
That's all right.
The alternative instead of alternative is so as far as the government's
and encouragements. We don't need to do anything further. Right, my lord. Item number 4. Item number 4, my lord, may I please your lordship. I filed an application for restoration, my lord. Application for restoration, my lord. All right, so the reason stated therein, the application, which reputation is this? That's not indicated. Reputation civil 9421 of 2003 is restored in the file of the Rasta bench. We listed there on 20th November. Supplementary list item number 5.
May I please, my lord? In this case, my lord, I have prayed for the modification of order dated 6th of July 2022. Arising out of IA filed by Union of India 8558. Lordship got it?
Yes.
Lordship, may kindly come to page 3, para 5.
Your lordship at great length has finished.
Yes, yes. There is the office memorandum number 01 within bracket 5/2021
/OF/DP within bracket TLGV/03 dated 24/9/2021. In the just below that, it was written copy enclosed, but neither copy was supplied to my lord, nor to me. Only the picture was supplied. And basing on the fake submission, my lord was pleased to direct them to the cause title of the petition was amended. But I have supplied the office memorandum. This office memorandum, upon decision on which my lord is directed, at para 5. Lordship, I am reading it out. In respect of the matter pertaining to the personnel within bracket government employees pending before various administrative tribunal, High Court and Supreme Courts, the new DPSU will be responsible to defend an assignee or successor in interest as per existing rule till the time of the employees are on deemed deputation with the new DPSU and protect the interest of Union of India. Now, next line, important. Except the pending matters being defended directly by OFB headquarters, Ordnance Factory Board headquarters at present, which would be defended by the directorate. Means Ordnance Factory Board will conduct those cases, not the new Defense Public Undertaking.
We're not inclined.
Yes, sir.
You say the court is not inclined to further modify the order dated 4/4/2020, 6/7/2022.
Matter is also fixed to 20th of.
Right.
Small question unnecessarily it is
Right.
getting forward.
Right. Right, sir? No. Namaste, sir.
Yes, admission item number 1.
My lord, I pray for a short adjournment.
So we can't adjourn, sir. This is a special bench.
Then I am submitting my lord. My lord, this is a review application, my lord. I am, your lordship kindly turn to page 10 of my lord's order dated 7/12/2021, my lord.
Yes.
My lord, the paragraph 1, I am not fleshing. I am not, I am concerned about paragraph 2, my lord. As regard the first player, Lord and Counsel for NHI informed the court that the petition vendor has already collected the compensation amount and therefore the remedy lies in the civil court. It is open to the parties to seek appropriate remedy in the civil court in accordance with law. My lord, in a similarly situated case, my lord, my lord has passed order. Your lordship kindly turn to page 6, paragraph 6. Page 6 of paragraph 6 of my review application, my lord.
Yes.
That is it pertinent to mention that in similar situated cases belong to village Lungeri, compensation amount has already been paid to the petitioner in double petition number so and so, disposed of on 25/8/2021, wherein the opposite party took the same plea that the compensation amount has already been paid to the petitioner in the said application. Hence, they are not entitled to get the compensation amount.
No, to the vendor of the petitioner, sir. Vendor of the petitioner. You are just changing the words now. The order we have passed is compensation has been paid to your vendor.
Yes, my lord.
That's not what you are saying in para 6.
But my lord, the paragraph.
You made a mistake, sir. There's a distinction. What we have said in our order is that compensation has already been paid to your vendor. So you have to now you file a civil suit against your vendor for the recovery.
It may be a dispute between the
vendor and him. That's what.
Yes.
You said there's no ground made out for review. Dismissed. Yes.
Item number 2.
2, 3, 4, your lordship office note. Correction of.
Yeah, all that corrections are carried out. As pointed out.
4.
Yeah.
Item number 5.
Review petition has been filed in final order passed in AHO.
It's a civil dispute. Dispute arises out of a suit for partition. In fact, there has been bit accidental confusion so far as the properties described in the impugned order or the order passed by your lordships in the HM law. In fact, there are two schedules of properties in the same name. Same name, that is schedule Go. It has been indicated in paragraph 15 and 16 of the order passed by lordships under review. One schedule Go is in the document under Exhibit N. That is a deed of partition, which was also under dispute. Another is schedule Go of the plaintiff. The same name, but described in two different parts of the suit. Now, the dispute was whether Exhibit N was valid or not. It was decided by the learned trial court that the Exhibit N is valid, and by the Honorable Single Judge also, Exhibit N is valid. Therefore, the schedule Go property under Exhibit N is to be partitioned. There is also no dispute. We don't dispute also that. But so far as the properties covered under schedule Go of plaintiff is concerned, that was held to be exclusive property of the defendant number 1, which is not partible. That was also held by the Honorable Single Judge. Here, Lord, kindly have a glance at the paragraph 15 and 16 of the order passed by your lordships in AHO. There is some clarification is required because that schedule Go in two places it has been intermingled. I think that so it has to be clarified. I have also served copy on my learned friend who was appearing for the appellant, but there is also limitation. If he's not here, then we have to wait for him, sir. Can't do it ex parte. You appeared, you did not appear, I think, in the original, but I have annexed Annexure 2. In the list itself, my name did not appear. I have Annexure 2, kindly have a glance. Item number 7.
Anyway, you say a copy of this has been served on Mr. Pal?
Yes, yes, I have served it, received it with me.
All right. You see Mr. Avijit Pal appearing for the appellants. Has been, the court is informed that Mr. Avijit Pal, learned counsel, the appellants, has been served with a copy of the review petition. However, he does not appear today in case of justice on 4th November.
His name may be indicated in the cause list.
Yeah, name be shown in the cause list. Right.
Item number 6.
In item 6, I was to file a reply affidavit to the extensive affidavit. I have got the documents. I inform my learned friend. I may be pardoned, my lord. I couldn't file the affidavit. May I pray for 15 days time, my lord?
All right. Mr. Samir Mishra says he'll file his affidavit within 2 weeks. List on 18 November. All right.
Obliged.
Item number 7.
My lords, item 7.
In item number 7, just now they have served a copy of the rejoinder. I have to take certain instructions on the factual issues.
Rejoinder has been handed over in court today.
It's all admitted, my lords. They also admit. Oh, factually.
List on 18 November.
Deeply obliged.
All right.
Obliged.